বছরে দাগ দিয়ে দিয়ে অনেক শব্দ দাগ দিয়ে
বোর্ডে দেখাচ্ছে 3, বোর্ড শো করছে 3।
হাসকল দিয়ে দিই। হ্যাঁ, আবার হাসকল
এটা হাসকল।
4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 4, 5, 28, 27, 28, 9, 30, 1, 2, 3, 34, 35, 36, 37, 38, 3.
Item 3, my lord, what happened? My lord, minor girl, my lord, the fled, and my lord, the direction issued by this honorable court, and thereafter police boy. Minor boy. Item number 3, my lord. Ruma Udhikari, my lord. You are for the petition? Yes, my lord. It's a minor girl, my lord. My lord, studying in class 10, and then my lord fled, and thereafter my lord police to her, and finally rescued her, and brought to my lord her native place, and thereafter again fled with the boy. And this minor girl is, she is yet to obtain, my lord, the majority and all this thing. Thereafter, my lord, very recently the family member of the girl went there and recovered the girl from Bihar itself and brought to her to her native place. And police, my lord, day before yesterday, since the matter is appearing before the honorable court, are taken to them to the custody, and thereafter, my lord, relegated to my lord, in a home, my lord, yesterday. That being the situation. Now, my lord, the family, after a long time, after 1 year, they have taken decision since marriage had taken place. They intend to, my lord, settle this matter. My lord, leave may kindly be given, my lord, to pursue, my lord, with the appropriate authority for release of the girl from the. That liberty may kindly be given.
The appearing for the petitioner submits that the victim girl has already been recovered and has been handed over to a home.
To a home. Know the name of the home?
My lord, that is in the Baghanda, Jangipura, Hooghly. Baghanda, Jangipura, Hooghly.
Hooghly district welfare committee?
No, it is within Jangipura police station. Let that be mentioned, my lord.
So that is under the child welfare.
Child welfare, lord. That is in the Uttarpara. Possibly they are operating from the Uttarpara.
And is presently
under the supervision.
Home under the supervision of the child's welfare
Committee concerned.
Under the concerned child welfare committee.
Concerned district.
In the district of Hooghly. Stop. In view thereof, no further order is required to be passed in the present application, and the habeas and the same is accordingly disposed of. There shall, however, be no
Only one liberty, the parents will
be disposed of.
recorded, otherwise, difficulties are there.
Difficult.
There is
So,
a provision.
That's
yes,
no problem.
দুইটা জানলেন না
কুড়িটা পাস ওভার হয়েছিল। adjourned. দেখি ফাইলটা দাও। No one appears on behalf of the appellant and no accommodation has been sought for. Stop. Accordingly, the appeal
কানেক্টেড অ্যাপ্লিকেশন আছে
and the connected application are dismissed for default.
পুলিশ ইলেকশন হবে বলে ও রিলিজ করেছে
As the order impugned in the present appeal has been passed by one of us, bracket এ আমার নাম দিয়ে, comma, the matter stands released from our list. Against the appeal. এ তো দেখছি গ্রুপ 3 মনে হয়।
হ্যাঁ কি রেসপেক্টিভ অফ ক্লাসিফিকেশন আছে শুধুয়ারি করে পাঠিয়ে দিয়েছে গ্রুপ 9
Okay.
Y goes to
last still the payment নিশ্চয়ই রিজলভ হয়ে গেছে।
back.
এই ওইটা কোড নাম্বারটা কত দেখেছেন? রিসিডিউয়ারি কোডটা 12,600 বলছে।
Total non-affairs, no. To represent the appellant, no accommodation has been sought for. Accommodation connected application business procedure. Interim order আছে নাকি? No, no. It's agreed for non-granting of new electricity connection to him. Distribution is directed to grant new electricity connection to the petitioner upon completion of formalities. In the event police assistance is
private
required.
respondent
Same
order.
Same order.
অ্যাপেলেন্ট না অ্যাপেলেন্টস দেখে নিন, অ্যাপেলেন্ট না অ্যাপেলেন্টস দেখে নিন, নাম্বারটা চেক করুন।
Respondent হচ্ছে নাম্বার 9 to 11 আপনি লিগালি করছে আপনাকে।
Still responding.
Same order, তাই তো?
Same order. Condition matter residual paper. So same order. Residual. Residual. Same order.
Lord, I appear for the appellant, my lord. Lord, pursuant to your lordship's direction, I served a notice. Day before yesterday, the matter was taken up. They didn't appear. Thereafter, I served a notice, my lord.
Mr. Roy, yesterday we have been told that the state panel has changed. You are appearing?
My lord, Mr. Shishanu Bandyopadhyay and Mr. Akhay Kumar Nag are appearing on behalf of state in this matter.
Where are they?
They are appearing for courtroom number 5, my lord. Courtroom number 5 and courtroom number 1.
So the matter is repeatedly appearing. You people do not appear.
Kindly grant a short pass over, my lord. I'll inform them, my lord.
Inform them. Reply they have filed, Mr. Roy.
My lord, they have not filed reply.
We keep it then next Tuesday. You inform Mr. Shishanno Bandyopadhyay that we take it up on Tuesday. If reply is to be filed by them, let them file.
Within the stipulated period, they have not filed. Even after that, they have not filed.
No,
So
it
they have
was.
waived their rights to file such.
Mr. Roy, we asked them as to whether your contention can be accepted.
Fine.
They opposed.
Fine.
Now you said that you will come with further records. That's why we gave you the opportunity. Have you prepared the supplementary affidavit?
My lord, it is ready. It is yesterday, day before yesterday.
Ashok,
My
Mr.
lord, one
Royal
more
Learned
indulgence. My lord, last order on which my lord, the direction to file reply was filed. It has not yet been uploaded, my lord.
Then we will
On the
proceed
website.
on the basis of this.
Well, the order may kindly be uploaded, my lord, so that for
What
communication.
order uploaded?
This cannot be an excuse.
This
my
is
lord.
the third word order uploaded
No, my
already.
lord, not uploaded.
What?
The order has not been uploaded, my
Who
lord.
told you? Have you checked up?
Yes, my lord.
This has already been third word.
And they were very much present when the order was passed. Last time also, my lord, they have taken on the same plea.
No, last time also the order was not uploaded.
ও জানি না বিপটা হঠাৎ করে এসে
Mr. Royal Learned Advocate appearing for the appellant files the supplementary affidavit. Stop, let the same be kept on record. Next, he
My lord,
informs us
pursuant to
that
lordship's direction, notice was duly served upon them.
he informs us that the copy of the supplementary affidavit has already been served upon the
On 4/5, on 4/5.
has already been served upon the
রেসপন্ডেন্ট নাম্বার 4 and 5
respondent numbers 4 and 5, but they have not yet filed the reply.
ইয়ে
My lord, on 4th May it was served, not 4 and 5 minutes.
মিস্টার রয় রেসপন্ডেন্ট নাম্বার 4
No. Which respondent?
My lord, respondent, that is state respondent, my lord, upon the state
আমাদের
respondent.
রেসপন্ডেন্ট স্টেট রেসপন্ডেন্ট only up to 3
Today, an adjournment has been prayed for. Today, an adjournment has been, today the learned advocate appearing for the respondents prays for extension of time to file the reply. Stop. As a last chance, the time to file such reply is extended.
Lord, Mr. Nagis.
এক সপ্তাহ দিয়ে
আজকে কত তারিখ?
আজ হচ্ছে 14
Yes, why you have not filed your reply?
My lord, the difficulty was we were trying to place the order on the last occasion before the officers, my lord, for the file, my lord. There was no order uploaded, my lord. That precluded us from finalizing the affidavits.
The order was
Told
passed.
you it has been uploaded.
It has not been uploaded in the
কোথায়? কে
কি বলে,
order
server,
দিয়েছে?
my lord.
অভিজিৎ, এটা সার্ভার লেখা আছে আপলোডেড হয়নি বলছে।
My lord,
Check করুন তো,
my lord,
just
even
wait.
now we are checking. It is
Yeah, just
28,
a moment.
my lord.
There may be some internet glitch. It has been servered.
But my lord, we have continuously checked, my lord, because my lord, there was an order
So
which
now
was.
the respondent advocate will appear, will hear about the order, but
Lord-
they will not comply unless the
My
order
lord,
is
my lord,
uploaded.
the
Don't
difficulty, my
make
lord.
these silly
My
submissions.
lord, my lord, my lord, why I am saying so, my lord, on the last occasion, my lord,
Your
the-
respondents wait for the court server order. If
my
they
lord,
do not,
my lord will kindly listen to me once, my lord. My
Yes.
lord, on the last occasion, the point was that there was a like kind of a directions from the court, my lord, that whether we can consider and settle the matter in dispute, my lord.
Hmm.
Accordingly, reports were prepared, my lord. Reports were placed. My learned senior friend on the other side was not satisfied with the report, my lord. Thereafter, it was decided that it will be contested, my lord. That was the only reason, my lord, we were precluded from finalizing. We are in the verge of
how you are
finalizing, but
precluded. That is why this order was passed in your presence. He was short for leave to file. Anyway, let us not go into that, but it is preferable if you do not argue in such a manner.
no, my lord, only because there was a point of
So
settlement, my
only
lord,
because
we
the
were,
order has not been servered, you have not complied. That is your ground.
my lord, not
Ask your officer to be here. Let
No,
us
my lord, it
inquire
is-
from him.
it is,
The
my lord will kindly not give such a direction, my lord. The only difficulty was we could not
he should
bring
be
it.
cautious. Neither he listens to our officer, and he is so audacious that he's sitting in office and say, let the court upload the order, then I will
Lord,
comply.
it is not that so, my lord. We wanted only to
Your
finalize.
junior for the first time said that it was not served. You come later, we find your name is there, you were there present. And now you say my officer is not in a position because the
Milord,
order.
there
is
was
not-
because Milord, we had moved the file for settlement, Milord, because it was the desire which had fallen from the court, Milord. However, terms was not agreed upon, Milord. That's why the matter went up
How
to
that
contest,
can
Milord.
preclude you from filing the reply?
Milord, we shall file it in a week, Milord. Only
That ought to have been your submission.
Milord, that
Huh?
oh, Milord,
You are arguing with the
no,
court.
no, Milord, we will file it in a week, Milord. Only in a week, Milord. Only the point was, Milord, we could not place the order in the file.
কোন অফিসার অর্ডার নিয়েছেন দেখো সার্ভার্ড হয়েছে কিনা all the matters are served তাহলে why the served indication was given এস লেখা আছে কেন
এটা কিন্তু আগেও একবার হয়েছে এই ম্যাটার মনে করে দেখো আগেও
Yes, communication is enough.
সেটা না কিন্তু এই ম্যাটারে আগেও সার্ভার হয়নি আপলোড
না করি এস লিখে দেওয়াটা না করে এস লিখে দেওয়াটা ইয়ে না তো আমরা এস লিখে দেওয়ার সঙ্গে সঙ্গে আমরা ইয়ে করছি করে তো একটু এম্বারাসিং
তাহলে কেন
কন্ডিশন
case recording হচ্ছে?
তাহলে they will enable it.
তো তোমরা
সেই
check
জন্যই
করো
তো
না
they
পরে
will
যে
সেই জন্য
server
অফিসার বললেন যে নট এগ্রি আমি তো
server
বলেছিলাম
বলো কিনা তো confirmation হচ্ছে।
সাপ্লিমেন্টারি বলে
এবার থেকে একটু করে নেবে অসুবিধা তো কিছু একটা ক্লিকিং অফ বাটনস তো
আমরা সঙ্গে সঙ্গে ডিপার্টমেন্ট
তাহলে আর এই এম্বারেসড হতে হয় না তুমি যখন আজকে সার্ভার করলে এস লিখে দিলে তো তুমি পরের দিন একটু চেক আপ করে নাও না এই ফাইলটা ঠিক আছে সার্ভার করে দিচ্ছি তোমরা একটু অ্যাসিস্ট না করলে তো আমরা পারবো না আর তুমি হিয়ার দিস সর্ট অফ আর্গুমেন্টস হু ইজ দি কনসার্নড অফিসার তোমাদের কম্পিউটারে কে আছে হেড কে
এটা কিন্তু দু তিনবার হয়েছে
এই ইয়েকে ডাকো রেজিস্টার লিস্টিং কে ডাকো রেজিস্টার লিস্টিং কে ডেকে পাঠাও আর কম্পিউটারের কে আপনাদের সিনিয়র অফিসার কে আছে
এই রমেশ ধারা
আস্ক হার টু বি হিয়ার
9 নম্বরে
ডেকে পাঠাও
কি বলছিস
একটা দিন টাইম এক্সটেন্ডেড ফর 1 উইক হয়েছিল
পাসওয়ার্ড করে রাখো
It was the usual practice, my lord. Most of the years we have done that the lawyers' communication is to be, my lord, given honor.
Milord, I bow down to what even my learned senior friend is saying, Milord. Just because we had moved the file in a way, Milord, we did not want, because a monetary value is involved. That is the only difficulty we were facing.
And before Justice Dr. my lord, in the identical matter, my lord, unless the officer comes before the court, nothing was paid, my lord.
No, ma, the content of the officer comes.
No, retain. Retain all documents to be brought.
হোক না হোক all documents to be brought.
লিখেছো অর্ডারটা এবার থেকে পান তুমি তোমার লোকেদের বলে দেবে যে তুমি যেটা সার্ভার করে দিলে ম্যাটারটা তোমার নাম্বারটা একটু কষ্ট করে লিখে দেবে তাহলে আমরা ফলো আপ করতে পারবো লাইভ স্ট্রিমিং হচ্ছে এত তো ডেভেলপমেন্ট হচ্ছে তারপরে কেন এটা হবে
এবারে কি লাইভ স্ট্রিম হচ্ছে
কি লিখেছো 5 লেট ডে এটা কি এটা লেখো Mr. Nag, learned advocate appearing for the state respondents, prays for extension of time to file the reply. Stop. As a last chance, comma, the time to file such reply is extended till. Yes, tell us.
a week
You tell us
Not a
and
week.
ask your junior to note the date.
No, Milord,
When do you find?
Milord.
When will you file the reply? Tell us.
the affidavit in opposition, Milord, within a week.
Reply to the supplement. So they have filed a
Reply.
supplementary evidence.
Yes,
Milord.
To reply, হবে না।
Milord, reply will be filed by
Opposition as a last chance time to file such affidavit in opposition.
to the supplementation.
Supplementary affidavit is extended till কত তারিখ? Extended till 21st. Stop. Reply thereto if any be filed by 27th. Stop. List the matter. 27. As for orders in the daily supplementary list of this court on 28th.
But when your lord sublegend. Sublegend. Grateful, your lords. But my lord, he immediately after receipt of the opposition, my lord, on 4th May, they could have come
Mr.
before
Roy,
this
you have
court.
heard what we have told them.
My lord, they could have come before your lordship and say that it was
Yes,
not
next
served.
matter.
সবাই আছে
তাহলে 11 11
My lord, may I briefly tell your lordship the facts? The writ petition was disposed of without affidavits. But in the appeal, pursuant to orders passed in appeal, my lord, affidavits have been exchanged.
2011 matter.
My lord.
Who is for the railways?
My lord, friend is appearing.
Affidavits exchanged.
In appeal.
একটা ইনফর্মাল পেপার বুক তৈরি করে দেবে দরকার নেই, সবই তো আছে।
Yes, tell us.
My lord. My lord, this relates to
One opposition.
my lord, my lord.
এই এখান থেকে বের করে দাও তো। Stay memo of appeal, stay application, opposition আর reply.
There are addition to this, my lord, based on subsequent facts, there are 2 supplementaries which has been filed pursuant to leave, to which oppositions have been filed by the railways.
You have given your reply also.
Yes.
রিপ্লাই আছে
Yes. What is the matter
My
about
lord, the issue relates to,
punitive charges,
my lord,
penalty?
no, my lord, wharfage and stacking charges. My lord, the petitioner, if your lordship will kindly have a look at the cause title ones.
So what was under challenge in the writ
My lord,
petition?
what had happened is an inspection was carried out by the officers of the railway, my lord, at the railway siding in Barbil station. My lord, pursuant to such alleged inspection carried out in December 2006, my lord, a demand was raised for stacking charges. So, my lord, the demand was based on a finding made in the inspection that they found, my lord, iron ores to the extent of 29,000 stacked in the railway siding. So based on this finding, they assessed the wharfage charges or, my lord, the stacking charges and raised a demand on us. Well, once the demand was raised, we raised 2 fundamental objections. The first objection was, well, this inspection and the finding of the inspection, which was carried out admittedly without notice to us.
No, it was said, it was dismissed on the ground that this is not the appropriate forum.
Yes. So that the forum which has been held by the learned single judge to be the forum, according to the Railways Act, that forum does not have the jurisdiction.
Now, what has happened for these 9 years, 12 years,
The appeal is pending.
and no realization?
No, but there cannot be a realization,
Because, my lord, there is
but
an
there is a state, there's an interim order.
interim order.
Yes. But our fundamental question was,
Yes, my lord, we have filed the vacating application to that effect, my lord. That is 116.
This has not come at your mentioning. This is, we have brought the file.
My lord, admittedly, because in the year 2013, my lord, I cannot say that, my lord, in the year 2013, I have filed the vacating application. It is to be hard on in the year 2023. That I cannot say.
opposition দিয়েছো।
But we have filed the vacating application, my lord. Vacating of the interim order, that is can number 11165 of 2013.
13.
That is there.
So, my lord, what had happened is when we raised
Demand
two
is more
fundamental
than 100
objections.
crore.
No, my lord, 100 crore demand is based on what? So there has to be existence.
Have you replied to the vacating application?
No, my lord, the vacating application was never moved.
What is the number of the vacating?
My lord, 11165 of 2013.
এটা read করো।
Because, my lord,
Once
subject to lordship's kind sanction, my lord,
Yes,
can 2, old number is 11165, that is vacating my lord, of the interim order.
তো এসছে কি?
My lord, as it
আমাদের
appeared,
কাছে আছে, আমি কিন্তু দেখিনি vacating application।
11165.
that was a can 2 বলে যেটা লিখছে ওটাই 11165.
Can do is that is 11167,
which is our stay application.
That is stay application.
না না 11165
না 11165 নেই আমাদের কাছে।
নেই মানে সার্ভ করেছিল।
রেলওয়ে রেস্ট মানে
কপি দিয়ে দেবো।
দেখছি। মানে
Yes, yes,
11165
my lord, IA can 2 of 2013, old can number 11165 of 2013.
নেই আমাদের কাছে।
আমি কপি দিয়ে দেবো।
11165 is not there, my lord.
নেই লিস্টে অ্যাপিয়ার করছে। না না
when was the interim order passed?
interim order passed, my lord, in the 2011. A single line order.
না? Can 2. না এটা can stay application.
না না হ্যাঁ, পরের পাতাটা করে।
Have you served them, Mr. Banerjee?
Yes, my lord, I have served, my lord, according to my,
He was not there at that time.
I was also not there, my lord. My instruction, my lord, we have served.
We have there are other affidavits, but so far as what my learned friend is, the application we don't have.
We will hear the vacating application finished. If it is maintainable, we hear your matter. Because the issue was statutory committee was constituted.
Well, that PHOD committee, one of the principal, we raised two fundamental objections. I'll just take 2 minutes of your lordship's time.
No, we will, while deciding the vacating application,
Your lordship can hear it up and dispose of the appeal itself. Issue is the same. Whether,
very good.
As you, lord.
yes, my lord, lordship can hear the appeal. If my learned friends gives me a copy of the vacating application, lordship keeps any day, lordship can hear it out because the point is very limited.
আমি একটা জেরক্স করে তোমাকে দিয়ে দিই।
হ্যাঁ, দিয়ে দিও।
It's a vacating application. Now today, I don't know whether you can take, you won't be filing any opposition because stay application, all records are there.
Absolutely. And there are subsequent supplementary to which he has also used affidavits. I have used reply. So there is nothing which is, all pleadings, respective stand of the parties are on affidavit.
কাজ করুন, এটা অ্যাপ্লিকেশনটা রিকুয়েশন করে ডেট বলে সেদিনকে শোনাবে। Yes, agree to a date. We will hear.
Any date, my lord, subject to lordship's kind sanction.
Yes,
Any date, any date.
দেখি বলো করো 27 জুন করো 28 পর্যন্ত ভর্তি 2 PM ভর্তি আমার তাই তো একটা
Only 27 June টা করো।
3 p.m.
সেই 3:30 হবে তখন তো ওই ভয় তো ছুটি
ফোন থেকে আমি কি করে
এটা জেরক্স করে জেরক্স করে দিয়ে দিতে হবে জেরক্স করে দিতে হবে।
they use Android na
দেখো কি না
they don't want to use that like my wife that is in sync with my wife
কারণ হচ্ছে আমার 100 কোটি টাকা সাবজেক্ট এটা
আমি আমার Android টা use
They have agreed. Ajay, don't you like it? PM break.
ভালো আই এম
Would you like
গ্রেটফুল
তোমার রিফ্লেক্টিভ সব দেওয়া হয়ে গেছে? কবে করে বলো? ফিক্স করো টাইম, সেদিন করো।
22nd বা 23rd ছাড়া যে কোনো দিন।
22nd, 23rd বাদে 24th,
22nd,
24th, 25th, 26th। কত দিন?
Lordship, I'm appearing for the respondent, number 1.
My lord, I appear for WBC DCL. My lord, the point involved in this matter is, my lord, whether WBC DCL can recover, my lord, the outstanding dues against in a property where new application has come up for connection, giving connection. I beg to state, my lord, once again, my lord, in the impugned order,
Just a moment.
চলছে।
You are appearing for which respondent?
Respondent number 1.
You were the rich petitioner. You were
Lordship.
the rich petitioner.
Lordship,
Now, who are the Standard Pharmaceuticals and Ramnik? Place it, Mr. Kindly show us the order in.
And my lord,
Lordship.
order impugned is at page, my lord, page 75 of the stay application. এই দেখি যাবে।
Is the presence of the other councils are not required?
Yes, secured, because case is this, it a huge property. Now, my lord, this Damani purchased a part of the property. Now, well, there is outstanding amount of rupees 5 lakhs and odd. Now, my lord, he is not willing to make any payment. Made application for new connection. Now, my lord, as per law, what we understand that we can recover. My lord, law says that the company
Covered from whom?
recover from the person who wants to have connection. Now, my lord, it is not possible for, my lord, the company to understand or to know as and when the erstwhile consumer or the existing consumer will sell the property and go, and, my lord, leave the entire dues unrecovered. That's why, my lord, laws are framed.
What was the dues were pertaining to?
Around 5 lakhs and odd
No, that was payable by whom?
by the erstwhile consumer who left the property.
Now the entire property is now under his possession.
Yes,
He wants fresh connection.
fresh connection. So we say, as per law, we are
The trial court say,
say that since affidavit was not used in the trial court, therefore the court said, my lord, we are not entitled to recover. We can recover the amount from the erstwhile consumer who was enjoying, not from the person who is making an application for new connection.
now new connection given.
And now, my lord, that's the issue. I am told by junior Mr. Mukherjee is also there. They are saying in the meantime, some development is taking place, as I am instructed and informed right now. So, my lord, that's a very vital issue. Apart from that,
If that is given, then there is nothing in the matter.
but our right to recover, my lord, even if I understand,
Right to recover can be decided in a better case in future, because in this case you have granted connection.
no, my lord, even then I will respectfully submit without any prejudice, this, even if it is, my lord, restored,
Mr. Nayak, how can they? Suppose you have a claim against
my lord.
that I have purchased that property. You have denied my claim because dues are there. Now subsequently with the passage of time, you have settled the matter, you have granted connection.
My lord, I respectfully, my lord, put this question to myself.
You
If
have
lordship-
got connection.
Lordship, we have got connection. We are still enjoying the connection. They are releasing bills. We are paying the bills.
So very good. Then where at the time of connection, did they claim any further amount from you?
They did not claim. They claimed. They sent us a quotation letter of the security deposit. We paid. They accepted.
and they restored the connection.
So that was
Restore the connection.
Subsequent to the order,
restoration or grant of
New electric connection.
new electric connection was granted.
where are those documents that quotation was issued?
Lordship may come to the
Regular term.
affidavit in opposition.
Affidavit in opposition.
My lord, what I base is lordship, without taking my lord's much time. Since the development has been reported right now, it has been taken place. Then two points remain for us to argue. Whether we can further proceed in the appeal, number one, and whether this my lord development has really been taken place without any undertaking or not. Two. And third, my lord, this issue has been decided by Supreme Court very recently on 19th of May 2003. What will be the consequences, whether we are entitled to or not? And our regulations are also here, my lord, under regulation 55, my lord, 4.3.2.
And
And
we come to the ordered impute.
yes, my lord, today I would like to, my lord, please, since this development, I must know this fact.
No, that was your specific claim, 5,73,000.
Yes, that was the claim.
Yes, now that claim you have foregone, you have granted connection.
My lord, under what condition was paying, I do not know, because this might be undertaking subject to the decision, subject to the result of this appeal.
ও একটা order order যে এই টাকা দাও তবে কানেকশন এই টাকা চাইনি কানেকশন দিয়ে দিয়েছে what remains to be decided
My lord, let me come back with the result. That is very relevant.
show us the connection order impugning the writ petition and the connection.
Instruction
Where
now?
is the
75 বলবো।
Lordship, in the impugned order, the appellants were directed, respondent number 4 is directed to effect electric connection to the premises of the petitioner within a period. We approached them, they initially refused to take the security deposit, saying that we will appeal. Then on 17th October 2016, after the date of the impugned order, they sent us a quotation letter of the security deposit of 96,440. That is at page 11 of the affidavit in opposition.
page 11
Of affidavit in opposition.
opposition you have not filed. Where is the opposition? Have you filed the opposition?
Lordship, I am not instructed in that.
You have not filed as yet? এই জানতে বাবু
Copy is with me, Lordship, of both affidavit in opposition and reply.
এই জয়ন্ত বলছে অপোজিশন রিপ্লাই ফাইল করেছে সেগুলো নেই
না ফাইল করলে তাহলে একটা রেকর্ডিং থাকবে না অর্ডারে ফাইল টুডে
No. এটা প্রথম যখন অ্যাফার্ম হয়, not that.
আসছিলই না
হ্যাঁ
in compliance of process has been communicated কেউ আসছিল না বলছে কোর্ট ডিরেক্টরি কিছু অ্যাডমিনিস্ট্রেটিভ নোটিশ এখন অ্যাপেলেন্স নোটিশ ইন দ্য নান হ্যাজ অ্যাপেলেন্স সেই জন্য সৃজন নায়ক অ্যাপিয়ার করছে 27/7/2021
এখানে হচ্ছে ডাইরেকশনটা দেওয়া হবে
Let ABTB shall file
তার আগে এদিকে এই অবস্থা
27/7
হ্যাঁ তারপরে এইটা কত
এটা তো আগের order
আর
27/7
না
No, there is no recording that you have filed the opposition.
you have
Lordship, I
prepared
am not instructed whether it has been filed or not, but there is a copy of affidavit in opposition as well as affidavit in reply in my in the brief that
it's
has
not
been
with
given.
the record
This is not with the record.
it was filed
My lord, I have no instruction as there is development that I have very initial stage, my lord, I have said. But this development has, my lord,
Was the connection effected?
my lord, I am not aware. I am not aware because it has been, my lord, given to me.
We know that. Please.
Lordship.
Yes, when was the connection given?
Lordship, security deposit was accepted on January 2017. Since then, we have the connection. And the
2017.
Lordship, and the last bill before the affidavit in opposition is annexed. The date of the bill is 29/5/2021. and the payment details.
So where is that? Where is the communication of 2nd June 2015? The order which was
Because of it.
impugned in the writ petition?
Hmm?
You have the stay application.
Lordship,
Where is that? You have the writ petition.
no, Your Lordship.
हाल नहीं करवाल नहीं मीडिया
My lord, it will be, my lord, it will be better, my lord, if lordship kindly, my lord, accommodate my prayer, what I am saying. This development has taken place, number one, and number two, my lord, Supreme Court has elaborately decided, my lord, this issue, taking into account, my lord, similar issues of Kerala, Madhya Pradesh, Rajasthan, West Bengal.
Mr. Nayak, if connection has been given,
Without prejudice, I tell you, during pendency of this appeal,
it's not your writ petition. Writ
No.
petition was another person. He
Yes.
said that you are not giving connection since you want some payment from.
my lord,
Writ court says that no such demand can be made.
My lord.
You preferred appeal.
my lord,
Writ court order was June 2016.
my lord.
Now you took the amount and granted connection. So we will record that your issue.
Lordship, not today. Kindly record it on the next day because I must get this information, number one. And number two, my lord, if there is an undertaking, because very well, let me give connection. But whatever the outcome, that will be binding upon me. That is why
Yes. that
I
your
want to know that, because how my client has done that without any intimation to us, that is also my lord question.
appeal has been preferred against.
I
the
want to take
order
instruction on this, lordship.
of June 2016. The present appeal has been by WBSCDCL
My lord,
challenging an order dated 15th of June 2016. Passed in a writ petition being AWP 8026W of 2016. Stop. Mr. Nayak Learned Advocate. Stop. What is your name?
Deborshi Das.
Mr. Das Learned Advocate appearing for the
Respondent number one.
respondent number one stroke writ petitioner
my lord.
submits that during pendency of the appeal,
Hmm.
electric connection has already been issued.
Granted.
Electric connection has already been granted in favor of the
The respondent number one.
On
respondent
acceptance.
number one. And that in view thereof, the present appeal in fact has become infructuous. Stop. Mr. Nayak Learned Advocate appearing for WPSCDCL, however, prays for an accommodation to avail necessary instruction. Stop. In view thereof, list the matter under the heading for orders in the daily supplementary list of this court on 20th June. And you come with all your records on that date.
Lordship.
All right.
Still, my lord, one question has to be, my lord, I will press your lordship to decide. If law says we are entitled to, and we can forgo this by saying whether we are entitled to recover or not. If law says we are entitled to,
Lordship, law also says that a nexus has to be established between
very
the
well, I will
erstwhile owner
place it,
and
my
the
lord,
new
to take
owner.
a decision on this. I respectfully submit, my lord, law says we are entitled to. Whether we can of our own say, no, we will not pay this.
Mr. Nayak,
I will
this
come
is
back.
an adversarial litigation. Your challenge, you did not come to high court.
Lordship,
You have come. Yes, next.
lordship,
Deeply
obliged to your lordship, I'm grateful, my lord.
Still. এটা পান ওই কম্পিউটার থেকে এসছে
28/2/2023 পর কোনো order।
2000-এর পর কোনো মামলা
কোনো
ওকে আমি জিজ্ঞেস করলাম যে তুমি যে বলছো যে আমার অফিসাররা ওটা যদি সার্ভারে দেয় দিয়ে স্যাটিসফাইড হয়ে না এসটা লিখছে, তো কি করতে হবে? বলছি যে না,
Beg to appear with the respondent, my lord. But pursuant to your lordship's, my lord, earlier direction of 16th of,
1 minute, 1 minute.
I'm sorry, I'm sorry,
There is a
I'm
judgment.
sorry, I'm sorry. Oh, sorry.
Mr. Roth's surname you spell as R-A-U-T.
Right.
Route.
Not as Rout, R-O-U-T-H.
ওই ছোটবেলায় কিরো করেছিল। হ্যাঁ, The appeal succeeds. Judgment impugn hearing is set aside. LA case number 30 of 2010, which was subsequently renumbered as OC number 21 of 2014, is dismissed. Parties to bear their own cost.
My lord, I am for the appellant, and one is my restoration application, my lord.
But,
And one is my restoration application. The appeal was dismissed for default, my lord, on 2nd December 21.
but, if your lordship, my lord, kindly sees my lord's earlier order dated, my lord, 16th of May 2023, my lord, where my lord, lordship has been pleased to, my lord, grant me leave so that I can file in opposition to the application for the restoration as well as the section 5. My lord, I've done that, and my lord, I tried to, my lord, serve the copies on to the learned advocate on record, my lord, which was refused, my lord. And since there has been a change of lawyers, they said, but I do not know that, my lord, why they did not accept the opposition. May I file the oppositions before your lordships, my lord?
My lord, can one is for restoration, my lord, and can 2 is for condonation of delay, and can 3 is for substitution upon setting aside of the abatement, my lord. The 3 applications, my lord.
First, it has to be restored.
Yes, ma'am. Yes, ma'am.
My lord, I use this opposition, my lord, again.
Have you got the copies of
My
this?
lord,
I have
they
not got
refused.
the copy, my lord.
They refused, my lord. My lord, yesterday also.
Mr. Royal under the advocate appearing for the respondent files the affidavits in opposition to the applications being Can 1 of 2023 and Can 2 of 2020. Stop. Let the same be kept on record. Stop. Copies of the same have been handed over to Mr. Kumar.
My lord, Anurag Bagadia.
Oh, sorry. Handed over to Mr. Bagadia, learned advocate, appearing for the appellants in court today. Stop. He prays for extension of time to file replies to the said opposition, said affidavits in opposition. Let such reply, let the replies be filed within a week.
My lord, my lord.
Within a week from date. Replied within a week from date is the matter for further consideration on.
Days. 394 days.
22nd. 22nd.
Yes, sir.
Grateful.
My lord, for responding UCO Bank. Lord, this my appeal, my lord.
Applicationটা কিসের?
This is my appeal, my lord. And I am
What is the application?
glad.
Pursuant to the earlier order.
আচ্ছা। সে ব্যাংক ম্যাটার। ইউকো ফোর্স ডি যে বেছে দিয়েছে সেম টাইপ।
You have served.
Yes, yes.
Where is your affidavit of service?
The address given in the cost title, my lord, husband, wife. Both are husband, wife, my lord. Address given in the cost title, one of them has received and one of them intimation sub, same address, husband, wife. And the other place, that auction purchase place, there, my lord, it was not delivered, my lord. Locked. It is door locked. Additionally, I have sub there also. প্রপার্টি না সেখানে কেউ নেই।
Item deliver, item on hold.
Husband serve হয়েছে, wife এর লেখা আছে intimation serve. এটা হচ্ছে
13th has received.
Item deliver wife.
Aisha Mumtaz.
Aisha Mumtaz intimation served. Wife,
Aisha Mumtaz sir.
intimation served.
Eh?
Aisha Mumtaz intimation served. Wife and Fardin Rahmat service complete. Same address.
You have given them the stay application.
But I have just given them the notice.
stay application টা appeal move করার সময় তখন সার্ভিস হচ্ছে।
Stay application was served.
At that relevant point of time, we have it's
Which relevant point of?
at the time of filing, moving the stay application.
নাম চাইছে। দেখো নাম চাইছে।
What was the order of 29 July?
29 July is the order by which the court directed the ombudsman to
You are in possession of the.
no.
No,
I was dispossessed. And the auction purchaser of central bank was in possession. And court directed to maintain status quo. That is the position.
Tell us the story. What is the matter?
I applied on the basis of the sell notice. I succeeded. I deposed.
Sonali.
I deposited the money.
How much?
This is around 15 lakhs.
15 lakhs.
17 lakhs 51,000.
17 lakhs 51,000.
Yes.
Very good. Then what happened? When was you? Have you made a
Only sale certificate was issued and the delivery opposition was made. Now I approached this read court, not seeking my direction that you restore me and execute sale deed.
court said go to civil court?
Read court said go to civil court. Thereafter, we prefer appeal. Our contention is this is a dispute between those two centralized banks. Therefore, read court should intervene and do justice. Because
Sale on as is where is basis.
yes.
Then what happened?
Now, read court took cognizance of our submission and directed the ombudsman,
Appellate court to court.
appellate court, yes, to inquire into the issue after giving opportunity of hearing all the concerned, central bank, UCO bank, as well as me.
And Hadat also.
Must be. Now,
A short list of this was prepared.
So your lordship can.
now the factual finding has now been made by the ombudsman. If you kindly takes up the order,
What is the factual finding?
factual finding is that there is a dispute who is the actual original title deed holder. That is not been decided by the ombudsman, because UCO bank says the original is with them. Central bank also says original is with them.
No criminal proceeding initiated.
That I do not know whether any criminal proceeding has been initiated. That bank can apprise. Now I am
Mr. Rai or Mr. Chakraborty, did you file any complaint to the police?
No, my lord, so far as UCO Bank is concerned, we had given, and so thereafter, so far as UCO Bank,
A person has played fraud. one of the deeds must be ingenuine.
Yes, my lord. But so far as from the ombudsman's report, if your lordship, I was submitting on the last occasion, at page 6, the ombudsman has very categorically recorded that the deed submitted to UCO Bank by the mortgager is the original deed. If your lordship takes up page 6 of the report. Yes, my lord. So far as we are concerned, we according to us, we are secured because we had the original deed, and the original deed was thereafter handed over to the writ petitioner.
But the auction purchaser from
UCO Bank. From the UCO Bank.
I am
my
from
lord.
the UCO Bank.
According to the
and the property mortgage to both the banks is the same property,
Same property.
yes.
same deed,
Same.
No, my lord. Our mortgage was much earlier. Much earlier.
different deeds. Who was the first? UCO was.
UCO was the first mortgage. Mortgage was first made in with the UCO.
Then how many years thereafter the second mortgage?
After 4 years. One is 2005, one is 2009.
So two different deeds.
Yes, sir.
Now then, what is the problem?
The problem is that now that the ombudsman says
Is the subsequent auctioneer central bank? You have subsequently auctioned.
which one is the original, that can be decided by the civil court. One part is fraud at the instance of the person who has taken loan. That can be decided by the police investigation. That is at the instance of the bank, complaint has to be made.
Investigation has.
But that bank can apprise whether they are supposed to. They
So
should
far
have.
as we have nothing.
Disposes from the property, they should have taken it.
They had made a one. Repetition লিখেছি আর সেটা আমি দেখাতে তো হবে ও বলবে কেন
Take the application before the
Repetition টা
before the court. The
But-
moment it disposes from the court, from the property,
repetitionটা
Yes.
Now that ombudsman ultimately observed that it has to be decided by the civil courts which one is the original, because none of the bank can now say after the observation of
You are wanting now.
that the recommendation made by the ombudsman is refund of money, and that the honorable court by its order dated 29 July 2019 empower the ombudsman to do justice in the matter.
All right. First show us the order.
Kindly take some order dated 29 July 2019.
More কাছে আছে।
29 July of
29
Order of-
July 2019.
order of appeal,
Order of appeal. Yes.
order under appeal.
Passed by,
First show us the writ court order.
yes. 156.
Oh, you have signed the paper.
দিয়েছিল জানো একটা মনে হয়, ওরা বলেছিল এটা।
Ombudsman-এর ইয়েটা আলাদা রেখে দিতে।
আচ্ছা, after this you handed over.
That you
My
could
lord,
have handed over,
this is the note UCO Bank has prepared in respect of the report, ombudsman report. On the last occasion, your lordship was, I just handed over because
Now, while this, at page 156, the order of single judge, at the relevant point of time, we did not have any knowledge that there was two original deeds. The two original deeds, it was not revealed at the relevant point of time. While passing this writ course order.
You have given a list of this.
yes, my lord, just now. Short, very short list.
This was revealed only in course of proceedings before the ombudsman. That there was two original deeds.
Where is the it is a flat.
It is a flat.
So for this flat, first mortgage was by UCO.
UCO.
That deed particulars, where do we find?
My lord,
The report contains that flat.
my lord, your lordship takes up the report at page, I think 6.
Number. Page 4 onwards,
All right, we shall find.
Yes, my lord. Page 4, CN number 4.
অরিজিনাল ডিট করেছে তার
Same
মানে হচ্ছে
property number.
একই প্রপার্টি
আমরা
কি রেজিস্ট্রি করেছে
kindly take sublet page 8.
অরিজিনাল ডিট না হলে বেরোবে না Display করেছে তো বাবা।
নাও না, কেন তুই মাঝখান থেকে না হচ্ছে ওকে বলছি তো তো না বুঝতে না বুঝলি তুমি মাঝখান থেকে ধরে আরো খেতে যাবে তুমি বুঝো না কেন
ইম্পোর্টটা পুরো পরে
দুটো দিকে এবার একটা দিক দিয়ে একটা চলে নিয়েছে একটা দিক দিয়ে।
না ডিটটা যেটা
The deed number are difference.
মানে kindly take sublet page 8 of the report. এই দলিলটা পরে রজু করা
Don't let us not go in a haphazard manner. Let us understand what was the
Actually, by the,
what was the
all the observation in respect to the list of dates and everything are observed by the merchant court.
I think
will suffice, my lord.
let him place the report in full.
The deed of act, one deed of convenience was registered on 5th January 2005. Another one,
That is
That was so far as the UCO Bank is concerned.
this ombudsman report?
Please don't.
What is copy is it?
Right, kindly take sublet page 2 first. The scope of inquiry
Please.
From
From the top, please.
from the top, yes. The writ petitioner purchased certain immovable property in a sale auction conducted by UCO Bank under the provision of Surface Act 2002. Though the price of flat as per the terms of the auction was paid, the UCO Bank did not complete the process of registration. Hence, the writ petition was filed seeking a direction to the UCO Bank to register the property or to return the amount paid to it. The UCO Bank opposed the return of amount on the ground that the writ petitioner were put in possession of the flat on October 15, 2014, after completion of process of sale, and it is not responsible for subsequent disposition. The Central Bank of India also entered appearance in the writ petition and stated that it sold the very same property to some other person in an auction under the Surface Act prior to the sale of UCO Bank. The single judge of the Honorable High Court refused to grant relief to the petitioners. Against the order of London single judge, writ appeal was preferred before the Honorable Division Bench, High Court, Calcutta. The Division Bench, by its order dated July 29, 2019, observed that to ensure confidence of those who buy such secured assets in auction by different banks, it is necessary to conduct an inquiry into the transactions of the UCO Bank and the Central Bank of India. In the circumstances, the Honorable High Court directed the banking ombudsman appointed under the Banking Ombudsman Act 2006 or any other succeeding scheme who has the authority over the territory of state of West Bengal to conduct an inquiry with liberty to exercise all parts in terms of Banking Ombudsman Act scheme, as well as such further authority as may be necessary for due conclusion of the inquiry. The report is directed to be submitted on or before November 15, 2019. The scope of inquiry. The Banking Ombudsman Scheme 2006 has been introduced by the Reserve Bank of India in exercise of parts conferred by Section 35A of the Banking Ombudsman Banking Regulations Act 1949. The deficiencies in banking services which falls under the scheme to lodge a complaint against the banks have been enumerated in paragraph 8 of the scheme. As per the scheme, the complaint against the action initiated by the bank under Surface Act 2002 does not fall within the scope of the scheme to entertain a complaint by the Banking Ombudsman. But in compliance to the order dated July 27, 2019, the Honorable High Court, Calcutta, in Matt Swanso, the Banking Ombudsman Calcutta conducted an inquiry with objective to ascertain the following. 1. Whether two banks followed due procedure and exercised due diligence in sanction of the loans to their respective borrowers in the instant case and ensured their respective unencumbered rights to the property against which they provided credit facility to two different borrowers. Two, how the two banks ensured unencumbered rights to the property were passed on to the buyers of the property through auction after invocation of Surface Act 2002. 3. Whether two banks took adequate measures to protect the interest of the respective auction purchasers of the property. 4. Systematic issue, if any, in the process of documentation of creation of charge by the creditors on immovable property. Approach followed in conducting the inquiry. During inquiry, the procedure followed by the both banks, the UCO Bank and the CVI, in sanction of the loans to their respective borrowers, post-sanction follow-up and recovery of possesses followed through auction process were looked into. For the purpose, the inquiry was based on following. A. Loan sanction documents and related case papers were obtained from two banks under certification that
Keep that portion. Hearing was conducted with petitioners and clarifications were received.
yes, notice of hearing was issued to the developer of the building containing the disputed flat, but the same was returned undelivered by the postal authorities with remarks address left. Inputs were obtained from the Development Banking Supervision, Reserve Bank of India, Kolkata. Observation made by the BO, examine the conveyance deed, the relative copies of the conveyance deed produced by the two banks showing sale the disputed property to the respective borrowers were examined and privacy revealed the following discrepancies. The property details mentioned by Central Bank of and the property details of UCO Bank. Flat number so and so, then remarks. Two flat numbers are apparently different. Flat number 312, third floor, and the UCO Bank flat number D2, third floor. Even the area is also different. Kindly see one of the remarks. Description of the property differs in terms of size of the flat and whether veranda and car parking space are included or not. Identification of the property is not supported by any approved floor plan in the case of UCO Bank. That they are supposed to do that at the time of mortgaging the property. Then the date of conveyance January 14, 2019 in case of UCO, and in case of Central Bank July 5, 2005. So UCO is prior the deed. Then vendor and then both are same. And then vendor nominee and with the remarks. Address and name of MD are same.
Vendors are the same.
Apparently same. SB Pal.
So SB Pal tendered those two deeds.
There must be some criminal proceeding against SB Pal.
Page 6, it has been very clearly stated that the vendor by some
Yes.
Then vendor nominee.
Developer's nominee.
Kindly see. Then again same. Then the remarks. Address and name of the MD are same in both the cases, but the name of the developer slightly differs. Person who has signed on behalf of the developer in both the cases is same. That is, seller is the same in both sets of document. So it is a collusion between the seller and the purchaser, the developer and the purchaser. Then summary. Summary observation in connection with the conveyance of the deed. The UCO Bank could not produce copy of approved floor plan, completion certificate, ready for possession certificate to show that these had been obtained and examined before sanction of the housing loan. 2. Significant differences were observed in description of the property, although the same property had been mortgaged to both the bank by their respective borrowers. Both banks produced photocopies of the certified copies of the a relative conveyance deed showing title in favor of their respective borrowers supported by such report submitted by their advocates. 3. Address and name of the MD of the developer concerned are same in both the cases with slight difference in name of the developer. However, the person who signed the documents on behalf of the developer is same in both sets of documents. This leads one to infer that these differences were deliberately made to give an illusion on different properties being sold, although in reality the same property was sold twice by the same developer to two different buyers, once in 2005 and then again in 2009. After a time of
No, but the two different buyers, how can it? Oh, sold it to two different buyers.
Yes.
Yes, well, first to the mortgager of UCO Bank, if your lordship sees, to UCO Bank's client, Pooja and Jitendra Shoni. And then again in 2009, to CBI's client, Subrata Poddar, the mortgager of
Coming to
CBI.
that's later part that is clarified. Right? Then again, Milad,
That is a
into the-
developer ঝামেলাটা করেছে।
After time gap of
clause
four.
6 clarifies that.
না না প্রথমে প্রপার্টি
Developer.
ছিল পূজা এবং জিতেন্দ্র সোনিকে, তারপর সেই প্রপার্টি আবার 2009-তে বেচে
In both cases, vendors are same. SB Pal,
developer
developer.
Yes.
Yes, yes, yes.
owner
Both the developers, in both cases, developers are same.
Same property after selling it to one was again sold.
SB Pal
Yes, SB Pal
and the developer,
and the
the
developer.
property was
Why
developed.
Same developer sold it to how to two different buyers.
Two
Yes.
different parts. Yes, yes.
So for the second, then your lordship will appreciate.
Vendor
not-
is SP Pal.
Vendor SB Pal, in both cases, vendor is the developer.
No, no. Name of vendor is SB Pal.
Yes, he is the developer.
না
No, the company is the developer.
Company is the
company
developer.
is the developer.
Yes, yes. He is signing on behalf of the developer. In both cases, SB Pal is signing on behalf of developers.
Then who are the two different buyers?
Yes, in the next page.
One is Sony, this is
One is
Subrata
Subrata Poddar and other
that's
is
the second buyer. The first buyer is Pooja and Jitendra Soni.
and Jitendra Soni.
They were the buyer in 2005 and Subrata Poddar in 2009. So the same property is again being sold, which obviously leads to the second sale.
Description of property was different.
Yes,
No.
Intentionally different করেছিল, এটা 312 আর এটা হচ্ছে D2, 312 আর D2.
Why he said to two different buyers, once in 2005 and then in Subrata. Very
পূজাকে 2005-এ সুব্রতকে
CBI
দিল, সুব্রতকে দিল এইটায়
এইটাই
312 বলে 860 স্কোয়ার ফুট।
তাহলে ওই প্রপার্টিটা এক টেন্ডার করলো ফর অবটেনিং লোন কে? সুব্রত পোদ্দার পূজা সমিতা করেছিল।
পূজা সোনি ইউকো ব্যাংকের কাছ থেকে লোন নিয়েছিল,
পূজা সমির উপর থেকে নিল আর সুব্রত নিল
সেন্ট্রাল ব্যাংক। That means Subrata took loan from your bank. And
Yes.
from your bank, Pooja Soni and Jitendra
Yes,
Soni.
ma'am.
Yes, yes. That is clarified in clause 6.
but the flat is the same. Though
Flat,
the
flat,
dimension
flat, the
differs,
description of the flat is different.
Different.
but it is in the same.
It is in the same, actually it is same,
But in the same housing.
same house. But if I, as is where is basis, if I go for searching flat, then it will show like two different flat. It is not possible for any buyer to ascertain whether there is any incompetence or not.
Yes,
that-
continue.
Now, clause 6 flat, whether the two banks exercise due diligence in credit appraisal and sanction in the interest in instant case, the following were the observed. Now, let comments systematic issue. The remarks, while the CBI's borrower client was an employee of railway, UCO Bank's borrower was in business and had availed the loan from other bank too.
How did this finding was arrived at?
Now,
Availed loan from
explain-
other bank too.
Yes, ma'am. Explanation in the next page. Note, Puja Son credit facility of 11 lakhs as the proprieties
Well, this is in respect of some other property.
electronics
That has got nothing
on
to do with.
May 20, 2005 from UCO Bank against another property, that is flat number 2D, second floor, Dr. Rajkumar Kundu Lane, PS Shipur, Howrah, and created equitable mortgage by transfer of title deeds over the said property on December 30, 2005 to secure the credit facility. The EM was created by deposit of registered gift deed dated June 8, 2005, executed in favor of Pooja Soni by Jitendra Soni, her husband, as donor. The account became irregular subsequently and was categorized as NPA, for which SARFAESI proceedings were initiated on July 2, 2007. It is pertinent to note that even after the UCO shelter loan of 7.5 lakhs turned NPA on March 1, 2006, and the CC facility to Aviskar Electronics was renewed. In course of visiting the mortgage property in connection with the Enforcement SARFAESI Act, the UCO Bank found that a notice under the same act was already issued by a Punjab National Bank and was posted on the premises, thereby indicating symbolic possession by PNB on September 3, 2007 for a housing loan granted to those borrowers. On inquiry with the PNB, the UCO Bank came to know that the said flat was mortgaged with the PNB by deposit of a deed of conveyance dated March 9, 2004. The UCO Bank therefore concluded that the said gift deed dated June 8, 2005 had been prepared by Jitendra Soni in connivance with Pooja Soni to defraud it in order to avail loan in the name of Aviskar Electronics. The UCO Bank declared this cash credit loan as a fraud and lodged FIR with the police. In a write-up on this loan submitted to the Ombudsman Office in connection with the inquiry, the UCO Bank has indicated the possibility of involvement of guarantors, advocate, valuers, and other borrowers and other individuals.
So when they came to learn that on 8 June 2005, the fraud was perpetrated.
By this, yes, even then they have,
Of a different property by one of the said persons.
yes,
Again, that person was given a loan.
but again, then given loan has been given. That's the reason my conclusion has been drawn.
Yes.
Then, Malat, clause 2, date of loan sanction amount 12 June, January 2009, 7.49 lakhs. So far, Central Bank is concerned, and so far UCO, June 23, 2005.
So why this is required? The fact, this is in support of the note.
Yes, yes.
Now let us come to 7,
Now, Malat, kindly comes to Malat, page 8, Malat.
page 8.
8, clause 5. That particulars of the deed that was mortgaged, Malat.
So why, what is this table given?
The
In page
statement,
7, date of loan sanction amount
yes, yes.
that the property.
In our case,
This is not yours.
yes, this is our case, Malat. Page 5, clause 5, the registered deed that was mortgaged with the UCO Bank and the Central Bank.
Clause 5.
Clause 5. So far, Malat, UCO is concerned, the deed was registered on 14 January 2009, registered with the ADSR Alipur. That is the 2009.
No, registered.
Central Bank. I'm sorry.
Central Bank is to the,
Yes,
Yes,
sorry,
madam.
Central Bank, yes.
and UCO is 2005.
And UCO is 2005, 5th January 2005. Both were registered but in different registration office. Remarks. Then let how the security was credited. The remarks is both the banks stated that they have not got the equitable mortgage recorded in the book of the register of assurance. The system of EM registration is not prevailing in the state of West Bengal, although it is mandatory in some other states like Gujarat and Maharashtra, where it can be done with payment of some nominal fees. As such report could not have revealed creation of charge on the property, and there could always exist possibility of multiple financing against the same property. Then date of the loan turning NPA. The comment is that the UCO Bank's loan tenure was 60 months, but the loan became NPA within the first 8 months itself. Then taking over possession by the central bank on 15th April 2012, UCO Bank March 2012, then auction.
No, UCO Bank took physical possession, if your lordship sees, whereas Central Bank took symbolic.
Yes. Then
We had our board hung and everything.
the date of auction sale, so far UCO is concerned, on July, and so far Central Bank is concerned in the July 25, 2014, and the central UCO Bank is concerned on August 10, 2014. Then let kindly see clause 3, date of placing sale of auction notice in the newspaper. At the time of issuing sale notice in the newspaper, UCO Bank could have checked similar notice by CBI, which was published around 1 month before the UCO Bank.
ठीक है, बोलते रहो, लिखा है तो बोल-
The remarks. Clause 3. Therefore, CBI notice was within the knowledge of UCO Bank. And then clause 4. Details disclosed in the newspaper notification. Then identification number of the flat is different.
No, madam, no specific flat number mentioned in, so far as CPI. I'm sorry.
Yes.
Identification of the number of flat is different. Then clause 5, next page, page 11. Date of conducting auction proceeds. UCO Bank's e-auction is at later date. Analysis information regarding post-sale auction by bank. Date of intimation of enforcement of 13/4. So far, Central Bank is 15th April. UCO Bank prior March 23. Date of issuance of certificate of sale. Central Bank 17 September 2014. UCO is later, October 14, 2014. Date of handing over physical possession. Central Bank September 14. September 24, 2014. And the UCO Bank October 15, 2014.
Then UCO did not put you in possession.
UCO did put in possession.
When did you get the possession?
But on October 15, 2014.
But at that time,
Already Central Bank, somebody was in possession. Therefore,
No, that was not, so far as the writ petition is concerned.
15th October, when you go to take possession,
there was nobody. Bank put me in possession.
Vacant possession, my lord.
Vacant possession. How did the bank got this possession? I do not know. Whether dispossessing the previous occupier or not, I do not know. That bank can apprise.
My lord, we had the physical for,
Sir,
I'm sorry.
it's your chance. Now, when were you dispossessed?
I dispossessed on, let's just tell you.
Acha, you will come to the, we finish it up, just.
I'm giving the statement. Just.
Then summary of the statement of the petition.
Yes, ma'am. Just a second minute. Then let Page 12, let date of handing over original title deed to the auction buyer. So far, Central Bank is September 24, 2014, and UCO Bank October 15, 2014. Then that is the remarks has been given. Let. Then was summary statement of the petitioners. My statement was recorded. Let. Shall I read this? Yes. Thus, summary statement of the petitioners, Srimati Sonali Mukherjee. Sales certificate was issued to them by the UCO Bank on.
Not come across any notice of CPI. Verbally assured. Affirm nameplate. Use the flat. 10th March 2015. Found a new nameplate affixed.
Yes. Though verbally assured by it.
15th October 14.
Yes.
And 10th March 2015.
Yes.
Person is the bank.
General diary করে ফেলতে কত?
Went to police. You did not lodge complaint.
Like police has refused to take any complaint that I have say recorded.
That is your. You say you must take it.
Date ta date. Immediate.
Jonas different. So findings.
12th March. No. 12th March. One document লেখা কিনা দেখো যে feelings করো
Now, when did CBI hand over possession?
To-
Farhad?
Yes.
That
On-
was on 24th September 2014.
24th September 2014.
That is about 1 week ago.
Yes, yes. Rather 3 weeks, almost 3 weeks. Because possession was handed over to
15 October.
15 October.
So it
2
is-
weeks here and 6 days here.
that is was from- Read paragraph G,
Paragraph G.
page 17.
17.
Vishwajit Bhatta, chartered engineer, has submitted valuation report upon request stating his
Yes.
copies of many.
On the disputed property stating its market value was rupees so and so, reported by some of
Flat was under lock and key. It was further said during inspection in September 12. Caption flat was under lock from outside. The names of whom were written as mortgager of the main entry.
names of two nationalized banks were written as a mortgage on the flat, but the CBI officials entrance.
Identified the property.
Yes.
Valuer had also made a caption permanent as the whole is complete.
Is complete and ready to use. However, it was informed that from the site office and expecting two flats on the floor side, the first floor, all the flats were either locked or sealed from outside. And at the front face of all the doors, the names of the several branches of different nationalized banks were marked. This confirms that the CBI was not in physical possession of the flat at the time of selling it through e-auction, and that the property was not free from encumbrances as the name of two nationalized banks were written as mortgager of the flat on the main entrance door. Hence, it is observed the CBI sold the property knowing that the same was disputed and may not be free from encumbrances. Both the banks claims to have done due diligence and appraisal while sanctioning the loan. Both the banks have given copies of the relevant such reports and conveyance deed, etc. While both the bank contesting the claims to be in possession of the original title deeds of the same property, simultaneously may not be correct. We are not in a position to examine which bank is having original title deed and related papers. Dispute of title of the property between the borrowers of two banks requires full judicial scrutiny by civil court. Then, in the facts and circumstances stated above, keeping in mind the spirit and customers protection and the fact that the petitioners have made bona fide payment for the auction property to the UCO Bank in good faith, it will be fair that the sum paid by them be refunded with interest. That basically, the ombudsman has observed that there was lack of diligence on the part of both of banks, and therefore both are two nationalized banks.
এই যে জায়গাটাই তো দিয়ে দিবি এই যে
CBI was not equal. CBI. আগে এই লোকটাই ওদের ফ্রড প্র্যাকটিস করেছে। Was it backed by any representation to?
Yes, is a demand justice by learned advocate.
20th March.
My writ petition was filed on 20th March 2014, immediately, my lord.
20th March,
20th March 2014.
how 2014? You were dispossessed in March 2015.
No,
Typing is typing
see, yes. Oh, it may be. If it must be 15 then.
Your demand notice is of January 2019. What you are saying?
It must be typing error, my lord.
Page 84 of the paper. Wrote to UCO on 15th of January 2010. That is after 5 years. Your disposition was on 10th March 2015.
Right, immediately then my writ is 14th March 2015. Right.
You have to satisfy us that I purchase a flat. I am put in possession. I give my law. When on March 2015, I go and find somebody else is there. I will not go to the police. And will I sleep if the police does not accept the complaint?
My lord, on
The
12th.
make a demand notice 5 years there.
No.
Page 38.
Page 38, my lord.
Page 38.
10th I was dispossessed.
Page 38. Yes.
Page 38, my lord. On 12th March, I made representation, my lord.
Mr. Ahmed, what is their obligation ends once you are given possession?
Lad, we are before the reach court, and my the factual findings as in terms of the direction of the Honorable Division Bench, lad, is now before the court, and it is now apparent that the both of bank has lad failed to lad exercise due diligence while lad mortgaging, lad while lad giving the loan on my mortgage. Now lad ombudsman, the object of the passing of this order, previous order of the Honorable Division Bench.
এইটা ছাড়া সবই অর্থাৎ
This is one thing, lad.
ইউকো হচ্ছে সেল সার্টিফিকেট ইস্যু করেছিল পরে শুধু, আর তাছাড়া সবকটা কিন্তু ইউকো আগে আগে যাচ্ছে। হ্যাঁ, এই দেখুন অপশন আছে এইটা পরে দেখাচ্ছি কেন? আচ্ছা আচ্ছা ঠিক আছে। অপশন করেছে সিবিআই আগে অপশন করেছে। হ্যাঁ, সিবিআই আগে করেছে।
সিবিআই আগে ইস্যু করেছে।
হ্যাঁ, সিবিআই ইস্যু করেছে, অপশন আগে করেছে।
ও একটা এগেইনস্টে ওগুলো সিম্বলিক করেছে।
হ্যাঁ
সিবিআই আগে করেছে।
হ্যাঁ হ্যাঁ জানা হচ্ছে না।
আর যেটা সিবিআই এর ভুল, সেটা হচ্ছে ওরা যখন গেছিল তখন গিয়ে দেখলো দুটো ফ্ল্যাট আছে, সেল হয়নি।
ফোন করে জেনে নেবো ফাইলিং তো করতে পারে, করতে পারে, ফোন করে যাচ্ছে।
Anything else?
Now, lad, I do not have to submit this factual finding has not been assailed by any of the bank. Therefore, lad, as of now, the conclusion drawn by the ombudsman in terms of the direction of the Honorable Court to do justice in the matter, lad, needs to be carried on. Lad. That is my humble submission, lad.
And that was the object behind the passing of the order dated 29 July 2019. Which is also not in challenge.
What is your prayer?
Implementation of the now my prayer would be the implementation of the recommendation made by the Ombudsman in terms of the direction of the Honorable High Court Division Bench order. Kindly similar first Division Bench order.
What is the implementation of direction? Into what direction?
The refund of money. Kindly similar the order passed by the Honorable Division Bench. The second page. May I read that?
Have you annexed that paper book?
29 July.
একটাই copy আছে।
আছে
দেখো তো এখানে 29 জুলাই কপি আছে কিনা দেখো এই অর্ডারের কপি।
This is one copy I have left. Just a within letter. Yes, I have with me 2 copies.
Okay, we have got it.
Yes.
Now, from the first paragraph, first page, second paragraph. The writ petitioners, as we see from the facts of the case, are apparently between devil and the deep sea. First page, 29 July 2019. The reason behind passing the second paragraph, the writ appellants stroke writ petitioners, as we see from the facts of the case, are apparently between devil and the deep sea. The appellants are auction purchaser of the flat in a sale conducted by the UCO Bank under Surface Act. They are in possession of that apartment. However, the registration of the document was not done. They came to this court seeking a direction from the UCO Bank to register the document in their favor. Alternatively, they prayed for refund of amounts paid by them as purchase price in the sale conducted by the UCO Bank. In the writ petition, the Central Bank of India came out with a plea that the same security assets is the security asset offered to it and the security interest that the Central Bank of India had over the property was also put to the proceedings under Surface Act, and such property has been sold by the Central Bank of India as well. Thus, there could be competing claims in relation to the same flat or apartment. However, it is pointed out that the sale certificate issued by UCO Bank identifies a flat with a building number, but the sale certificate issued by the Central Bank of India does not carry any identification of the apartment on the basis of numbers. The UCO Bank and the Central Bank of India are nationalized banks. They are fall for adequate and appropriate control by Reserve Bank of India. This is not one of those cases where the matters cannot be left at the stage in which it has now reached. The learned single judge has ordered in the writ petition refusing relief claimed by the writ petitioners by way of refund of money. It has left the Central Bank of India and the UCO Bank to proceed as it may find appropriate. We think that the facts of the case in hand require deeper look to ensure that the confidence of those who buy such secured assets in auction by different banks are regulated as may be required. The very peculiar facts and circumstances of the case persuade us to direct an inquiry to be conducted into the transaction of UCO Bank and Central Bank of India, which have led to this litigation and proceedings which were carried by both these banks. Hence, we direct an inquiry as aforesaid shall be conducted by the appointed under the Banking Ombudsman Scheme 2006 or the succeeding scheme who has authority over the territory of State of West Bengal. The Banking Ombudsman will be at liberty to exercise all parts in terms of the Ombudsman scheme as well as such further authority. Now, this is given by the court as may be necessary for due conclusion to the inquiry ordered hereby. And for this second part of the direction, the direction was given by the Ombudsman, the recommendation. We are hereby authorize the Bank Ombudsman to exercise such parts. We do so it in exercise of writ jurisdiction. The banking ombudsman, having jurisdiction over the state of West Bengal, is required to conduct an inquiry following due procedure as to notice hearing, etc., and also maintaining confidentiality as may be found necessary and due. The inquiry shall be completed and report shall be submitted before this court on or before so and so date. Then the UCO Bank and the writ appellants are directed to mark their presence at the office when the procedure has been done. There is nothing.
Yes, Mr. Rai.
My lord, so far as the report is concerned, trying to from the A1, that first of all, in the report itself, as my learned friend had just placed before, from the concluding portion, first of all, they are saying that they are not in a position, so it should go before the civil court. So far as who is the original owner of the property, who has, so far as the property is concerned. And prior to that, at page 6, as again my learned friend has already placed, that when in 2005, when the mortgage was created, so far as the UCO Bank is concerned, at that point of time, even the mortgager of CBI, Central Bank, was not, he never had the property, not in the picture. So even if, so far as, because from the report, it is found that mortgage was created, so far as UCO Bank is concerned, in 2005, when the property was bought itself within few months. So at that point of time, the person who had mortgaged the property with CBI, Central Bank of India, was not in the picture because he had bought the property, according to him, in 2009. That is 4 years after the creation of mortgage. So far as UCO Bank is concerned, they had, with due diligence as a public authority, conducted, and obviously at that point of time there was nobody, even if subsequently some other person with some other name has once again, so which itself makes the sale bad of the property. So far as the UCO Bank is concerned, they had the original deed and they had conducted very diligently whatever has to be done under the law, and as such their mortgage, may I submit, was an original and legal mortgage. And thereafter, of course, again, as it appeared from this report, that the person who mortgaged with UCO Bank, with CBI, he never had physical possession, nor thereafter when the mortgage was called up by CBI, they also did not have physical possession. So this should lead to the conclusion that both the person who had mortgaged with CBI and CBI himself never actually had the position, legal position, if I may say, legal right, sorry, not position, legal right, so far as the property is concerned. So my humble submission is that when UCO Bank had the property, the person who had mortgaged, he had the property originally, and thereafter, in terms of the report, when he had mortgaged it much prior to, and thereafter he had given direct physical, even the retribution themselves have submitted there is nothing when they took possession, so far as CBI is concerned, marked on the property. So when, nothing, no wrong has been committed by UCO Bank. In
your case,
it was, I think, in 16 months, much before the in PA. Your lordship can my lord, MPA. Page 9. My lord, your lordship can page 9.
Your NPA was earlier.
Yes, my lord. I think 2012. We took possession, and prior to that NPA, I think 2011.
Kindly takes up page 9, let.
Sales certificate পড়ে দিও।
Well, in fact,
অপশনটা পড়ে দিও।
সেটা তো ওতে অ্যাডমিট করেছি, আরে ও তো অ্যাডমিট করেছি না, নেই তো, নেই তো ওরাই নিজে বলছে। Submission of so yeah, Sonal Mukherjee. No, no.
হ্যাঁ,
এবার অপশনটা করতে গেলে
একটু পরে হয়ে গেল।
অপশন
হ্যাঁ।
আর in fact, the sales certificate has
Bill. See,
না না
see, এই যে এইখানে পেজ 10, হ্যাঁ, এই হ্যাঁ, ডেট অফ টেকিং ওভার পয়সা
এই 23শে
মার্চ,
নেওয়ার সময় তাহলে এ সিম্বলিক পজিশন
এই সিম্বলিক পয়সা এই অপশনটা দেরি করে ফেলি। হ্যাঁ, পজিশন হ্যান্ডের উপর করছে ইয়ে, মানে বায়ার তখন অলরেডি সিবিআই ওর ইয়ে বায়ারকে করে দিয়ে।
জানি না আমি যদি
your lordship was when it was implement at page 9, if you have got it, your lordship, at bottom.
So your contention is that I have given physical possession.
My contention is that when I took the property as mortgage, equitable mortgage, it was totally free, because at that point of time, the person who is now claiming, I mean, later on, was never in the picture in 2006, 2005. Because I got the person who mortgaged the property with UCO Bank had bought in 2005 and mortgaged it in 2005. And the thing turned NPA in 2007, 2006. And thereafter surfaces started in 2007. So, so far as CBI, the person who had mortgaged, he had bought it in 2009, according to him. And it was purely on paper because he never had possession. He never gave possession. So UCO Bank or the person in who had mortgaged it with UCO Bank, they had the legal right and possession of the property from day one. So UCO Bank had diligently had conducted everything, and there was nothing wrong so far as UCO Bank is concerned. Neither can it be shown.
Because your issuance of sale certificate was
That could be later, but so far as the deed is concerned, which is the original type, because ultimately the property goes with the deed, the original title deed. Even if my sale certificate is issued later or not issued, that will not take away my right over the property as mortgagee, sorry. Because the title deed is the original one. Even the ombudsman is saying that.
said that they
No, my 2005 is admitting a property. He is saying that has been sold twice. First on 2005 and then on 2009. Now, I ask myself, a property already sold in 2005, is the second sale valid in the eye of law? Maybe a fraud is committed between by the original vendor. But why should the person who is bought be affected by that second sale? I bought something which is free for at the time of my buying. Somebody sells it later on by some other without telling me. Why should my title be bad? My title cannot be bad thereafter. For that.
handing over of deed.
No, my lord. My title means I am talking about the person who has mortgaged. He had bought it in 2005. And no, man, that is the record of the. And 2005, I have created mortgage. So at the time, yes, my lord, mortgage at that point of time, that.
Charge over.
He-
As a mortgagee,
Yeah.
you charge over.
I understand. No. I'm not saying title. What I'm saying, I'm now through this surface, I'm transferring the title
Yes.
to the writ petitioner. So according to me, my transfer of title to the writ petitioner is absolutely under the law legal and valid. Unless set aside by some legal proceeding which shows that there is some transfer of title is bad. That is why even the single judge and as well as the ombudsman has said that they should go before the single judge.
Single judge said.
Man, a single judge said that. Your Lordship, may I please the order of the single judge? Man, at page 156 of the paper book. May I place it, my lord? Yes, my lord. The petitioners seek registration of a deed of conveyance in respect of an immovable property purchased by the petitioners in a sale conducted by UCO Bank under the provisions of the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002. And in the alternative, refund of the purchase price. The learned advocate for the petitioners submits that the petitioners are interested to refund of the purchase price as there is a dispute between UCO Bank and Central Bank over the property. He submits that the participated in the sale process under the Act of 2002. They became successful therein. The sale was confirmed by UCO Bank on September 15, 2014, and the sales certificate was issued on October 14, 2014. The petitioners have since been dispossessed from the property on March 12, 2015. He refers to the affidavits used by UCO Bank and Central Bank of India and submits that there are disputes between the two banks with regard to the property concerned. In fitness of things, therefore, the court should direct UCO Bank to refund the purchase price to the petitioners. The learned advocate appearing for UCO Bank submits that the property was put on sale under the Act of 2002, where the petitioners had participated. The petitioners were declared as highest bidders on September 15, 2014, and the sale in favor of the petitioners was confirmed on that date. The petitioners had applied for extension of time to make full payment on September 18, 2014. The sales certificate was issued on October 14, 2014. The possession was made over on October 15, 2014. On November 14, 2014, the petitioner had asked for registration for the sale of the deed of conveyance. Thereafter, the petitioners on March 12, 2015 had raised complaint that the petitioners had been dispossessed from the property. The so-called dispossession happened subsequent to the sale, and the petitioners were put in possession of the property. The question of refund of price does not arise. The learned advocate appearing for Central Bank of India submits that Central Bank had also sold the property under the Act of 2002, and the sale was prior to the date of sale of UCO Bank. The respondent numbers 13 and 14 are purchaser of that immobile property. I have considered the rival contentions of the parties and the materials made available on record. The two prayers of the petitioners, one being alternative to the other, require consideration. The petitioners claim to have purchased the immobile property in an auction sale undertaken by UCO Bank under the Act 2002. UCO Bank acknowledges the petitioners to be the purchaser of the immobile property. It is the common case of the parties that petitioners had paid the entire consideration to UCO Bank. The entitlement of the petitioners to receive the deed of conveyance in respect of the property concerned is not denied by UCO Bank. In such circumstances, the petitioners are at liberty to obtain the conveyance from UCO Bank in respect of the property concerned in accordance with law. So far as refund of the purchase price is concerned, it appears that from records that the petitioners had participated in the sale conducted by UCO Bank. They were put in possession of the property concerned on October 15, 2014. They had issued a letter on November 14, 2014 to UCO Bank asking for execution of deed of conveyance. At no point prior to March 12, 2015, did the petitioners allege that they were dispossessed. Since the petitioners did we had complied with everything, including pictures in the paper. Yes.
No, in the report of ombudsman.
That has been not specifically mentioned, but it is there in the paperwork of the learned. The pictures also, and that is not disputed also that we are in possession. We were in possession.
Civil sitting with subsequent sale duty if found in respect of person is totally valid.
54. Because at the time of taking possession and putting the lock also, the local police and everybody was, your lordship takes page 54, page 54.
That is admitted.
That is admitted and that is not disputed over. And it is also not disputed that our deed is original and we had taken possession, we had possession, we handed over possession, everything was done. So nothing, no wrong so far as UCO Bank is concerned has been shown.
Why should I give loan to a person who had been 1 month ago a defaulter?
So that is a different question, my lord, with due respect, my lord.
Nationalized,
I understand, but so far as this thing is,
but a nationalized bank, and it is a question of equity
I-
has been highlighted.
I understand, my lord. You,
That of the
the
division
person who is, I understand, what the,
was clearly an equitable relief granted.
I understand.
So that order you have not challenged.
I am not saying anything. So far as the person who had mortgaged it in a different matter, he might have committed fraud, and we are also saying that. But so far as in this matter, there is no fraud from their side. We have checked it, and there is no fraud from our side while handing over to the writ petitioner. So when that is there, then the question of handing over the money, because then the sale has to be set aside. First of all, just by saying that you hand over the money, you cannot. It's a nationalized bank. So let him get the sale set aside. Or we cannot. We cannot just come in and say you pay the money. No.
For deed execution of deed of conveyance, sale certificate itself.
Yes, my lord.
So sale certificate, the REIT court has the jurisdiction to set it aside. We are a REIT court, not a question.
No, but so far as because when you're if you're
Supreme Court says.
then when if your lordship is setting aside my sale, then your lordship will consider these that I had the original deed. So thereafter, if your lordship,
Your argument is that what is my fault?
yes, my lord.
Taken a property on mortgage.
Yes, my lord.
In usual terms of bank, I have, it became NPA, I took all procedure, I took possession, I handed over physical possession.
Yes,
Now
my lord.
you are asking me to give back the money.
Yes, my lord.
This is your call.
Yes, my lord.
That we understand.
Yes, my lord.
But the question is, you cannot say that REIT court cannot.
No, I'm not saying that. I'm saying that my learned friend, I have never questioned the judicial writ court. Otherwise, I could have. I am not. My saying that they are asking that because in none of their because in none of their prayer, my lord, they have asked for setting aside the sale.
They will not do so. They will return me the money.
Anyway, that is why.
Return me the money.
Because then they could have asked for the setting aside the sale.
Yes.
কিন্তু ব্রো তো বারবার সিবিআই ক্ষেত্রে এরকম হচ্ছে কেন? হ্যাঁ?
After submission of report by ombudsman, we have nothing to say more. We're putting the
Mr. Ahmed just answered us this thing that you are seeking an equitable deed. You are saying what is my fault? What is my fault? You
Exactly,
give back-
equitable relief.
But the thing is that there is some infraction as regards late approach to the bank, whatever it may, but that has subsequently division. But what is their fault? Their fault, UCO Bank.
Fault of the UCO Bank.
Yes. What is the
That fault of
consider this and come and tell us tomorrow. This argument of his, you please answer.
yes, right.
Your his REIT court is, you are asking from the REIT court that you REIT court cannot give title, give
No, no.
possession handover.
No.
That is the single judge's. So the only window which has been left by the REIT court
It's equitable
that
relief.
I am considering whether on equitable terms you
Yes,
can be
yes,
given
yes.
back.
That is our only prayer.
No, that prayer was turned down on the ground. There has been a delayed approach. Possession was October 2015, November 2015 dispossessed. You file complaint in March 2015. That is what the court has said. Now, UCO has taken mortgage. It became NPA. They put it up on auction sale. You are the highest bidder. UCO took possession of the flat and given you possession. UCO becomes
But
functus.
to seek equitable relief, I have to demonstrate before the court that I have come before this court at the first instance. And that there was no delay.
We are seeking two answers from you. First is your conduct, how you explain that, and the second is answer to this question that
What
why
fault they
today-
have?
Today, if UCO gives you back the money, he will never get it back from fighting a legal battle with CBI. He'll never get it back. And moreover, we could have understood that that you were in symbolic possession. They said that I will give it to you 2 weeks later. Come again. That is not the fact situation.
That they can pay us and recover from the concerned.
Why? Why?
In Motor Vehicles Act, that this principle follows, Milad.
Because from whom?
From the central bank, Milad.
How?
How?
But
Who will decide the legality of the deed?
that's the civil code that the ombudsman has said.
Yes, you have to. So, civil code. Why should a bank be punished when they have taken possession and they have given you possession?
Milad, why should I?
You should
Why should I be punished?
You are
Milad,
not being punished.
Milad,
You are an unfortunate sufferer.
Milad, why shall I? That's so, Milad, the order of the division bench started the fight between Milad Deep Sea and Milad.
We have delivered a judgment in similar fact situation, and we have allowed the appeal given the relief. We have not given interest, we have not given stamp duty, etc. In that case, it was not actual possession. You give us any authority, we can give your judgment, our judgment reference, we can hand it over to you.
Milad, may I
That
go through that?
judgment is in your favor, but only that point. We were minded to give that order in your favor.
Milad, may I get
Whether
reference of that order?
Central Bank has taken any step in respect of or on receipt of such report from ombudsman?
My lord.
Report
My
of the
lord, but-
ombudsman indicates that the subsequent sale held in 2009 and all act done on the basis of such sale are
Bad.
void.
We handed over the possession.
So your sale proceed, everything will go.
We handed over the possession and there is no complaint by the purchaser. Still they are in possession. Still they are in possession. We handed over the
Powerful
possession after execution of registration.
They are powerful persons. Fault was created by you. Why did you give symbolic possession?
Not my lord, symbolic possession. We have given.
You are in symbolic possession.
You took
They are-
symbolic possession.
We sold the property on symbolic possession, but we handed over the possession and already after handing over all the documents along with the possession physical possession of the property.
Only you held e-auction prior to holding by UCO, and you gave possession earlier to.
No, not possession, my lord. Because when they took the possession, it was free from any income.
Yes.
Only thereafter it was broke open by the person who is presently in possession. So they had also given payment after. Only they had conducted prior to that.
Mr. Chakraborty, your possession, you have handed over title deed to the auction.
And
You have handed over physical possession on 24th September 2014. And they handed over possession in October 2014. So when they went to take possession, there was nobody in the flat. On the contrary, when you handed over possession, when
there
your
is no
officer-
nobody. Yes.
No, you found 2 notices struck there that 2 nationalized banks' names are there. নিজের গণ্ডি সামলাও এবার। So it comes back to you. You answered to us. You answered this. Then why your entire proceedings, whatever you conducted, everything
In the
will-
year 2009, in the year
Yes.
2009, when the
When
year
you received-
2009, bank sanctioned the loan
Yes,
in the year 2009.
that was a
In
fraud.
in case of
You take steps against
my lord, in 2 cases, in that not one is fraud, one is original. 2 deeds are original. It is now multiple deeds. Same vendor, same developer.
affidavit of service filed by the appellants be kept on record. Stop. No one appears today on behalf of the private respondent numbers. Taken you. Listen, stop. We have heard the learned at respondent number ta বসিয়ে দেবে stop.
13 and 14 service. 13 and 14 service and 13 and 14.
How many flats are there in the apartment?
They are now they're not now in that apartment. Oh, that I do not know.
Flat number 312.
Yes, by Central Bank of India.
এই তো ইয়ে হওয়া উচিত।
And in case of State Bank of India, UCO Bank, it
All
is
are frivolous.
flat along with
D2.
car,
Flat number D2.
along with one car. And measurement is different.
Can it be in the second half tomorrow, let?
CBI-টা গেল।
Hardly learned advocates appearing for the respective parties. Yes, tell us when can you give the reply?
Can it be tomorrow in the second half, let?
তো সময় সব সুরজিৎ কিছু আছে? We keep it on 11টার সময়।
QPM চাইছে 3 PM
আপনার সময় লাগে তো লং রেট নিয়ে নিন
Matter for further consideration on 15th as marked as fixed at 3 PM.
Tomorrow at 3 PM.
I'm grateful a lot.
কোনটা ফিক্সড আছে গাই?
আমার তো
এখানে 1400টা বলে দিচ্ছি। সই কালকে দেখবেন এই এভাবে 1400 আরবিট্রেশন ক্লজ জয়েন্টলি আসে মেকন লক্ষ্মী
ফ্রাইডে কি সিঙ্গেল বেঞ্চ আছে আমার?
পরের সপ্তাহে বিলে সোমবার।
Maybe on next week, my lord.
no, next week I have some problem. My lord, let it be tomorrow or day after tomorrow. This week, let it, because
No, tomorrow day after tomorrow.
On
Subject to ability of our.
on 20th as fixed at 11 AM. 20th is a Tuesday.
my lord, I have some problem next week. So this week, problem next.
Oh, Mr.
Achha,
You won't be there.
I might not be. Not that I will be. I may. Anyway, if your lordship is fixing, then I have to adjust. Something.
29.
On 29th as fixed at 11 AM.
I am grateful, Allah.
Excuse my indulgence, my lord, with regard to
Just a moment. Mr. Ahmed, you on this, you satisfy us on that.
with regard to item 18, my lord, probably my lord may not take up this matter because this is a group 7 matter, my lord.
11.
Do you have checked up?
I have checked up. It's a group 7 joint prayer, my lord. 18. Essential service under group 7. Essential service.
29th is a
My lord, that's what Mr. Ahmed is saying. It could be Eid on that day.
Oh, acha.
26 কি আছে কি ব্যাপার হচ্ছে?
Then it will be on 3rd July as fixed at
আসলে অনেকগুলো হলো তো
5th July করে দাও as fixed
তারিখে
at
একটু
11 AM.
যদি
নেই তো কিছু? 5th July you finish it up. 5th July as fixed at 11 AM. Acha,
Item number 18 may be released, my lord.
On the joint prayer of the parties, the matter stands released as hardly learned. 18
এটা আলাদা
এটা কোনটা?
এটা এইখানকার
ফাইলটা দিকে আগে কি অর্ডার ফর্ডার করা ছিল নাকি? ওই 18 নম্বর ফাইলটা দাও। কেন determination is given 12 what you are showing?
residuary
Residuary you are showing filed as residuary.
Residuary?
On the joint prayer of the parties, the matter stands released from our list, since we do not have the determination to hear this. But a writ petition.
Residuary তো নয়। Group 7 residuary ওরা কোথা থেকে দেখাচ্ছে? Group 7?
Petition residuary, where from you are getting?
না, Group 7 কোথা থেকে দেখাচ্ছে?
Where it is residuary?
না, Group 7 where it is written?
Where is group 7?
Where it is written, the Group 7?
Where?
Where it is written?
Bottom? দেখি কি bottom?
Essential service. Petition was originally filed.
Bottom, where your group A read
Category, subcategory.
essential services. Where is group?
Where it is written that it is Group 2 matter?
Group 7 matter, where it is written, Mr. Ghosh?
It is filed as residuary matter in the department.
তাহলে ঠিক আছে, ছেড়ে দাও। Then it, my lord.
ছেড়ে দাও কেন? Unless you show us how can we?
That time, my lord, that the Honorable Justice Subrata Talukdar, he has no jurisdiction.
He has no determination.
No determination.
Writ petition you have filed under which group? Tell us.
Group 7.
Where from do we find it? Show us that group 7 matter.
Essential
Is
service, group
filing
7 na group
the
8
writ petition filing slip, presentation form. There you will get it. এখানে writ petition এসছে নাকি?
আচ্ছা, যখন ডাক হবে তখন।
এটা ডিপার্টমেন্টে নামিয়ে দাও। এটা ডিলিস্ট করে দাও, ওরা গিয়ে দেখুক। হ্যাঁ, না অর্ডার করবো না, ওরা গিয়ে নিচে চেক করে আসুক।
Lordship adjourns it for a week so that we can get ample time to check it out.
Filed the department, you
The writ petition was filed by the.
I filed, but I was of the opinion that it was under Group 7, my lord. Group 7.
check it up and come and
Then
tell us.
1 week adjournment, my lord. Only 1 week.
This week.
Okay.
18টা not this week.
ঠিক আছে, আমি চেক করে আসছি।
Check it up and tell us.
May please. My lord, I have concluded my argument.
Yes, yes.
Only, my lord, I submitted before your lordship. I shall show to your lordship one judgment that when the charges against some person by name and others were acquitted, there must be at least 5 persons to award my lord the conviction under section 395, 396. Under the judgment, my lord.
Mr. Moitro, you said that you would be giving us a note.
Yes, my lord, that I have prepared. My lord, 1998 Supreme Court cases criminal.
1998
Supreme Court cases criminal, page 696, paragraph 9, my lord, only paragraph 9. Paragraph 7, sorry. Paragraph 7. Paragraph 7. There can be conviction under section 392, but there cannot be any conviction under section 395, 396. Here also, my lord, lordship kindly recall, charges were framed against the particular accused persons. And there is no, my lord, the rider along with other unknown persons. No, that in the charge, framing of the charge.
So your point is XYZ along with unknown person.
Had there been so, then if XYZ or XY was acquitted, others could be convicted under section 395, 396. But where charge is specifically against A, B, C, D, and A, B, C, D, if C, D goes, then singularly, my lord, solitary accused could not be convicted under section 395. Because, my lord, the law contemplates that there must be participation by 5 persons.
So one thing is 5% out of which some are known, some are unidentified.
Had there been so.
That is one case.
Yes.
Another case is 3 or 2 are identified. There is no proof that others were there.
There is no charge even. There is no charge even that 5 along with others or 6 along with others. Then if, my lord, 3 of these 6 named acquitted, other 3 could be convicted under section 395, since my lord, charge was along with unknown persons who could not be identified. But when charge is specifically pinpointing that these are the person, the participants of the commission of offense of dacoity, if the number reduced after the pronouncement of judgment reduced less than 5, then conviction could not be under section 395, 396. There could be conviction under section 392. That is for robbery, not for dacoity. And my lord, if they're convicted under section 392, maximum conviction is 8 years. Long before they serve time. Now they will argue, my lord.
Where is Mr. Chakraborty?
Well, I shall have it Xerox and give the.
You need not give us Xerox.
We'll take a printout.
Binding will get disturbed. We will get it.
Get it. But let them argue, I am.
Yes. Prosecution will be. প্রত্যেকটা দিকে একজন পারলে শূন্য সব ঘন্টার মধ্যে পিস দেবেন। আমরা কোনো একটা বেঞ্চ দেওয়ার জন্য Yes. You are for Chimu.
My lord, I'm for Chimu. My lord, your lordships may kindly come to the judgment first. My lord,
Paper 2 or 1.
3. My lord, judgment.
Oh, Joy, একটু দাও না। 3 টা। সাহেবেরটাও wait করুন। Not in 3. Page 178.
My lord, in the last part, 3 pages, I want beg to point out, my lord. The punishment that ordering portions. My lord, to point out, my lord, first I take the first, kindly excuse me, first I take the first page of the judgment. Your lordships may kindly come to paper book page, the judgment first page, the costatal of the
91.
judgment. My lord, that is in page 690.
In our, yes.
My lord, your lordships may kindly see state versus 21, apparently 21 accused persons. This is the first thing. Now your lordships may kindly come to the final sentencing portion. Your lordships will find before the sentencing portion last page, last but 2 pages, my lord. Page 744, page 744.
Internal page.
744, my lord. Internal page is, my lord, 55.
Yes.
Kindly excuse me, my lord, page 54, my lord. 54 is the relevant. My lord, 54, if your lordships kindly see, ordered there, these persons were acquitted. And my lord, also page, it starts from page 53, last 2 lines. prosecution has failed to prove 395, 396 against these persons. This comes down to, my lord, 11 from page 53, last but 2 lines, starts from Amanullah Bishwas to page 54, first 2 lines. My lord, this is in total 11. 11, these 11 persons acquitted of 395, 396, and from miscellaneous charges, after ordered, these persons, my lord, together it comes to 17 accused persons.
Yes.
My lord. Now, I beg to point out before your lordship,
Persons were convicted.
4 were convicted. Now, my lord's peculiarity of this case is, now
So why do you want to, why,
Yes.
why you are drawing our
my lord, because not only 395, 396 were not proved, but also 120B were 395, 396 of the Indian Penal Code read with 120B against Shubal Bakshi and Shaidul Karikar. My lord, just now I shall draw your lordship's kind attention to, my lord, charges. My lord, they are 120B charge. This 395, 396 read with 120B
395.
against Sirajul Karikar and Shubal Bakshi. My lord, this Shubal Bakshi and Sirajul Karikar, they were acquitted.
Shubal
Bakshi and Sirajul Karikar. I shall show to your lordships. Another angle
must be within those 11 persons.
My lord, Shubal Bakshi is not within that 11. In the ordered, that portion Shubal Bakshi is there. In 12 is Shubal Bakshi.
Yes.
And Sirajul Karikar is 2. Sarijul Karikar, he is 2. In ordered. These 2 were, my lord.
Sarijul Karikar, yes.
Sarijul, yes, my lord. But it will be appearing.
Saying these 2 persons?
My lord, these 2 were facing additional charges of 120B. 395, 396 with 120B, and they were shown as the main conspirators prior to the commission of those offenses. But that angle was disproved later on. Disproved or not proved, whatever, my lord. And these 2 persons, their acquittal, my lord, these all, though I am appearing for the appellants, my lord, none of the acquittal in respect of 17 persons were challenged by the prosecution. Your lordships kindly keep an, my lord, note about that. Together with a peculiar fact is that your lordships, the other day it fell from your lordships as to, my lord, ballistic report. My lord, perhaps there was no question of ballistic report because, my lord, from the lower court records I found, my lord, 25-27 Arms Act was there in the charge sheet. But in the charge, 25-27 Arms Act is missing because there was perhaps no sanction. And this vital aspect, my lord, though CID investigated, it was a hugely discussed matter. This, my lord, was this was, my lord, lost sight of. My lord, how this happened, I do not know. Because bullet injury of one bus driver is found. That is opined by PW, my lord, one doctor.
Go one by one.
My lord.
What is your first argument? 11 persons acquitted, not challenged. Sirajul and Shubal.
See, 17 persons acquitted, not challenged.
And Sirajul and Shubal was suffering an additional charge of 120B, which was not proved.
120B along with 395, 396.
Additional.
Yes. For commission of 395, 396, they conspired.
Very good.
Yes, but that too failed. That too failed. Now, your lordship kindly, my lord.
Then what is your argument?
Yes, my lord. My argument is, it is vital because 120B, as per prosecution, happened earlier. First, the incident happened on 5th, they said, intervening night of 5th and 6th February, and this conspiracy happened earlier, prior to that. So if conspiracy fails, not on the same date, conspiracy happened earlier, that failed as per the prosecution. This is vital because first conspiracy, thereafter arms will be procured or things will be planned, they will gather. Then, my lord, I beg to point out that the weapon of offense in this charge, the charges are 396. 396 is the charge. Now, my lord, 396 and 395, your lordships are, my lord, well aware, my lord. 302 is something, but 396 generally, in my humble opinion, is used when it is not very clear as to who of the total gang committing dacoity is committing the murder. Your lordships kindly have a look at 396 of the Indian penal code.
Hey, Joy.
396 is dacoity with murder.
Read permission work. সাথে কথা বলে। Yes.
My lord, whoever commits dacoity,
that is 390.
395. If any one of 5 or more persons, so minimum requirement is 5. If one of 5 or more persons who are conjointly committing dacoity commits murder in so committing dacoity, every one of those persons shall be punished with death or imprisonment for life or rigorous imprisonment for a term which may extend to 10 years and shall also be liable to fine. So requirement is one of 5 or more persons who are conjointly committing dacoity commits murder, then is important in so committing dacoity. So it will be in the same transaction. And your lordship will find in the charge, it was stated, you in furtherance of common intention committed dacoity and committed murder.
Charges where which page?
Fine. My lord, charge is in paper book, first paper book.
Page.
Yes, my lord. My lord, the page is my lord, page is 12. 12 is the total page. Total page 12, my lord. Yes. In the right hand side, it is written.
Yes.
14 named. Your lordships kindly have a look. Amanullah Vishwas, Shirajul Karikar, all these things. Chimu is in 14. You on the night of 5/2/2003 and 6/2/2003. Here I stop for a moment, my lord. In some charges, it is written in the intervening night between the 2 days, 5/2/2003 and 6/2/2003, which is perhaps meaningless. 5/2/2003 is a different date, 6/2/2003 is a different date. I shall be showing, my lord, in the charges they say, in the intervening night between 5/2 and 6/2, not in this charge, but in all other charges. Then, my lord, I continue this charge. On the night of 5/2/2003 and 6/2/2003 means on 2 days. At Aishmali within PS Dhantola, conjointly committed dacoity in respect of cash and other articles like gold and silver ornaments, watches, video cassettes belonging to Dilip Ghosh, Bonka Ghosh and others who are passengers of bus number WB512733 and WB512658.
Yes.
My lord, what I beg to point out, my lord, here the regarding 396 I was arguing committed dacoity, then in the second charge on or about 5/2 and 6/2 at about 1:20 AM of 6/2/2003, here it is specified. committed dacoity of such and such articles of 2 buses, 1 sumo car and 2 cycles. So 2 buses involved, your lordships kindly have a note, 2 buses involved, 1 sumo car involved and 2 cycles of 2 passers-by involved. So in all, 2 to 4, 2 buses, 1 sumo car 3 and 2 bicycles means 5 conveyances involved. And in the commission of such dacoity, murder of Shomir Kumar Ghosh, driver of WB51, was committed by one of your members. So therefore, which member it is not specified. So 396 was used only because the prosecution was not sure as to who had fired. This is one. Otherwise, they could have given 302. They did not. They said 396. But for 396, in my humble submission, my lord, one weapon of offense is required. For that, they forgot to take the sanction, and for that, they forgot to pursue 2527 of the Arms Act. They only, my lord, seized the empty bullet cartridges, but they did not get it, my lord, matched by ballistic experts report. That is not there. And 2527 Arms Act, no sanction was used, but charge sheet was given under that section. This is one very vital aspect. Together with that, certain other peculiar angles are there. My lord, actually, as per prosecution, it will appear to your lordships that this case involved allegedly rape of 3 victim ladies. 3, not 1. And my lord, 354 of at least 3 to 4 victim ladies. Therefore, not of single lady, but one of the victim lady also turned hostile as per the judgment. And it is not very clear as to who did what, and I shall be showing to your lordships, as per 376 2G, there were 3 charges. And against Lodhai, a single charge of 376 was there because he was arrested later on. So, my lord, I beg to point out again, my lord, that weapon of offense was never proved, never seized from anybody, never proved. So, this vital aspect, if not proved, then murder using 396, my lord, will suffer a setback, in my humble opinion. And my lord, together with that, why I said number of victims, your lordships will find from the 313 examinations, one person was there who also allegedly raped, but he, along with at least 4 to 5 accused persons, were never arrested by the CID. Therefore, my lord, 396 charges apparently brought against certain persons, but a number of persons, at least 5 from the lower court records I found, against them proclamation was pending. They were not arrested. My lord, they were given a go by. So we never know if at all murder happened as to who actually fired, because my lord, so far I found weapon of offense was not seized from any of them. Therefore, as to who fired, maybe a person was killed. Now, if that is found to be genuine by the postmortem report, then the next question comes as to from the which weapon it was fired at, he was fired at, and that was seized from whom. My lord, seizure is not proved by them, and the weapon of offense is also not proved by my lord ballistic expert's opinion, as also my lord that therefore 396 will go, because the charge, your lordship knows, my lord, it is stated only section of the charge will be sufficient also. But then the ingredients, each and every ingredient has to be proved. 395 each and every ingredient, and also 396 each and every ingredient. And your lordship will find another defect in the trial was charges were framed not at one go, at phases. Judge, not the same judge, different judges also framed the charges. And my lord, before framing of the charges, with greatest respect to them, my lord, they never waited for the other accused to come in the fold And also, my lord, before framing of the charge, charges actually, my lord, dealt upon this, my lord, prosecution. My lord, I shall be showing before your lordships these 14 accused persons. It was stated clearly that they did the commit the dacoity and the murder. Then your lordships, my learned senior advocate, senior friend had shown, my lord, what was the effect of the single charge of Kurban. It was, my lord, just did in a hurry, perhaps. Your lordships will, my lord, just for the sake of repetition, there it was stated, Kurban Ali, you along with other accused persons of this case at about 1:20 AM on the intervening night of 5th and 6th February.
Where is that charge sheet?
Yes, my lord, that is in page 9 of the paper book.
Page 9 is those 14 persons.
My lord, that is page 12. Page 12, 14.
Page 9.
Page 9. Page 9 of Kurban. Kurban later on arrested. Their charge of 2003, 24 September 2003. Kurban's charge of 2nd April 2005. Almost nearly after 2 years.
It's down now.
Paper book first part, my lord. Page 9, my lord. Right hand side page is written, my lord.
No, page 9. 8 and 8 and 8 because
My lord, Kurban Ali Mondal, that you, along with other accused persons of this case, this is very vague. At about 1:20 AM.
Why you are saying vague? The earlier one was charge framing against 14% was on 24th September 2003.
My lord, but subject to your lordship's kind sanction, this case means entire case. Therefore,
along with connected co-accused
this
persons
case, it is stated this case, my lord.
Where you are
not the charges framed against earlier persons. My lord, Kurban Ali Mondal, first 2 lines, that you, along with other accused persons of this case, not only of the persons charged against, to 14 plus 115, 14 plus 115, but Kurban's charge says you along with others, not specifically those 14. This is one.
No, it is along with co-accused persons.
Yes, but
their names were co-accused at that juncture will be which persons? Suppose charge has not been framed against them.
But my lord, subject to your lordship's kind sanction, charge has
argument. What you are trying to
my lord, I want to beg to point out.
Not involved.
My lord, I beg to point out the prosecution was never sure as to who were the persons they wanting to proceed against. Because with these two, now your lordships may kindly come to the most vital portion, that is in page 21, that 120B. Kindly have a look at this charge. Page 21, my lord, right hand side.
Yes.
2 persons, my lord, Shubal Bakchi and Shaidul Karikar.
120B.
Date is, my lord, 24/9/2003. These two were admittedly not on the spot as per prosecution. My lord, they, now I read it, my lord, that you, a few days
prior to the incident.
Yes, man, I'm grateful, man. Not specifying on which date, but a few days. At the house of, this is important, my lord, accused Shubal Bakchi at Nopara PS Dhantola conspired with other Shaidul Islam Karikar. So actually wanted to say that Shubal, but
House of Shubal.
yes, no, my lord, I say in the charge you, they stated two names. Then he says that you means these two. Then he says with other accused Saidul Islam Karikar. So that's why I say, my lord, perhaps learned judge wanted to say Shubal Bakchi with Shaidul Karikar, but whatever it may be, learned judge wanted to say you along with Shaidul Islam Karikar to commit dacoity in respect of the cash and valuables belonging to the bridal party of the marriage of Kartik Ghosh of Kuchiamari on the night of 5/2/2003 and 6/2/2003 on the way back home after his marriage, and in pursuance of such conspiracy, the offense of dacoity with murder. This also, my lord, subject to my correction, my lord, appears to be somewhat, my lord, ingenuity of the prosecution, because at that stage murder could not have been planned. My lord, that is also very vague. Dacoity with murder, punishable under section 395, 396 of the Indian Penal Code.
In pursuance of such conspiracy, the offense was committed.
My lord, I stand corrected. So even if, my lord, conspiracy was for dacoity in respect of cash and valuables belonging to the bridal party, therefore, my lord, from here I want to point out, then the bridal party were not known to the accused persons. Nowhere it has come that the present petitioner Chimu Sardar or the others were aware that who were the bridal party. So unless it is proved that route where from the bridal party will be coming, by which bus they will be coming, it is not possible for the conspirators also to assess or instruct as to how the dacoity is to be committed. They say, your lordships, kindly read it once again, my lord. To commit dacoity in respect of the cash and valuables belonging to the bridal party of the marriage of Kartik Ghosh of Kuchiamari on the night of 5/2/2003 and 6/2/2003 on the way back home after his marriage, and in pursuance. So they were even aware that when they will be returning, then it will happen, apparently, as per this charge. So they have to then know about the route, where from and by which bus. So how did they know? I am asking this to myself. How did they know this bridal party of Kartik Ghosh by which bus they will be coming? Because nowhere it has come in evidence by the prosecution that these bus numbers were known to the conspirators or to the accused persons. And in the process, two buses were, my lord, stopped. Peculiarly enough, in one evidence, some of them has stated after one bus, one Tata Sumo vehicle stopped. And in the other evidences, it comes two buses were one after another. And your lordships will find nowhere it is very clear from the evidence of the passengers also who were in which bus. Nobody had pointed out that I was in this bus bearing number such and such.
All right.
Now your lordships may kindly come to another angle. One of the point of the prosecution was the male passengers were brought out. They were, my lord, put in the roof of the buses. Nowhere the buses were, my lord, inspected to, my lord, prove that there were ladders behind the buses. They stated that at that night they were brought out, the ladies were inside. My lord, two probabilities come out, if whether there were ladders, whether the prosecution case is at all believable, that the male members were segregated, and another angle, had they been segregated, they could never be the witness to the subject to, my lord, correction, never be witness to the crime committed to the female members because they were allegedly segregated. And my lord, regarding the place of occurrence also, charges simply stated Aish Mali, and one vital aspect I must point out, my lord, 412 of the Indian Penal Code was there. 412, my lord, learned judge did not specifically state anything, record anything. My lord, your lordships may kindly see 412 IPC was given. A number of charges. My lord, jewelry shop, where from allegedly, my lord, ornaments were recovered, where those were sold, some of them recovered, my lord, those were seized allegedly, but conviction, my lord, I do not find any conviction under 412. So if this angle also goes, my lord, that will also, my lord, have a, my lord, impact on the prosecution case, because 412 was their case. But conviction rested only on 395, 396, sorry, my lord, 396 IPC and 376 against a single person. No 412.
Yes.
My lord, another angle was this. Your lordships may kindly come to page 13 of the first paper book of the charge. No, your lordships may kindly first come to page 10 of the first paper book. This is the charge against Lodhai. Page 10. My lord, it is of 2008, months later, single 376 charge. The victim lady's name is there. I'm not mentioning, my lord. Your lordships will find 3 ladies, 376. 3 ladies. 2, their names starting with T and 1 with P. Now this lady, this is, my lord, 376. Then, my lord, I go to page 13. Page 13. This is a charge of 2003, 376 2G. Lodha, your lordships have found single 376 in respect of the name. My lord, actually I stand corrected. This is another name. So actually, my lord, 4 376 victims allegedly. This is another victim's name.
Chimu was included, page 13.
Yes, my lord. Chimu included,
You are
but
for
not
Chimu.
proved. Yes, my lord, but Chimu not proved. Chimu, regarding Chimu, 376 proved against only Lodhai. Only Lodhai. So, my lord, not in respect of the gang. In his respect only, it has been stated. So, we presume that he must have been convicted under the first one, this one. had he been convicted of 376 2G, my lord, in this 376 2G, Lodha is not there.
Convicted under 376.
6, that is, my lord, regarding, my lord, Lodhai. Lodhai is, my lord, T Ghosh. T Ghosh is there, and this one is R Ghosh, the victim. This is separate.
76 2G was not proved.
Yes, but my lord, Chimu 376 2G was there. Chimu acquitted. Regarding Chimu, there is no 376 2G.
Yes.
What I beg to point out, your lordship then kindly comes to another 376 charge. That is in page 17. This is another T Ghosh, not of the first 2008. This is another lady. My lord, page 10, that
No,
T
why
Ghosh
you are
lady.
going on that? You were
Fine.
convicted under 395, 396.
My lord,
You were not charged under 376.
my lord,
So
but
that aspect, so far as you are saying that the suspicion arises as regards the incident itself.
yes, my I am grateful, my lord. Regarding that, I am trying to,
You can restrict yourself so far as your case is concerned.
my lord, but only with your lordship's kind permission, my lord.
Uday has been addressed by him.
My lord, only to this extent. Regarding the, my lord, the things are to be from the angle of the, my lord, defense. I am trying to point out things are to be, if we take it in a together in a composite fashion, then also the story that bus was first stopped, first driver was shot at, then they asked the male members to be segregated, then they started looting articles and trying to search or task the ladies, and in the process they committed rape, brought out 2 or 3 ladies. My lord, these things also, my lord, I am saying certain elements also get disproved, because this 376 2G, there were 3 charges. These were not proved. Only a single person's charge. There also, my lord, no explanation is there. So I want to point out, if the sexual assault story is also not proved very clearly, then the links are not very, my lord, clear. That is my attempt. Only to that extent, my lord. So this is one charge, 376 2G, that is in page, my lord, 13. Another 376 2G charge is there. That is in page 18. Then, my lord, page 19 also another, regarding a different victim. Then 20 also. This 20, this charge, now your lordship may kindly compare this 20 with page 8. Page 8, my lord. The
Page 8.
victim's name, yes, my lord.
What is page 8? Page 8 is postmortem.
No, page 8 of the paper. Kindly excuse me, not page 8, my lord, of Lodhai. That is in page 11, my lord. Not page 11. Kindly.
Uday is 10.
Page 10. Yes, my lord. Page 10.
Lodhai is page 10.
Page 10.
Yes.
Page 10, your lordship kindly sees the victim name.
Yes.
And then page 20.
Same girl.
Same girl, same lady. So, subject to your lordship's kind sanction, this page 20 charge on 2003. 24th September 2003. And same lady,
2008.
2008. There your lordship sees
Only
how
once.
this Lodha is doing, along with whom. I want to point out that.
Here it is not along with.
I am grateful, my lord. I am grateful. I want to point out this to show how in such a matter, how in a hurry these things were done. Because perhaps it was done in phases, perhaps. Otherwise, this should not have happened. And the effect of acquittal of other accused from the charge, and not including Kurban. Kurban, subject to your lordship's kind sanction, will definitely get the help from the acquittal of others from 376 2G, because the victim is the same. and I want to, my lord, get the benefit saying that I was acquitted. So one ingredient of the offense was not proved. One component part which happened resultantly. Now your lordships may kindly keep, my lord, just I am repeating, my lord, 412, learned judge never a number of charges of
We have
412.
noted that.
Yes,
Next.
my lord. Number of 412, but none, no conviction awarded, therefore. Together with that, my lord, it will come to you before your lordships that the FIR.
Charge was framed under 412.
Yes, my lord.
412.
Yes, my lord. Kindly allow me, my lord. From page 11, my lord. From page 11, your lordships kindly see. This is separately against Lodai. Then, my lord, then
So 412 was not proved against anybody. 412 conviction was not
no,
there.
no.
Yes, what is your next argument?
My lord, then 412 series starts from page 22. One after another. And what they did, they, I do not know, my lord, the reasoning, subject to your lordship's kind sanction. They said this one article you stolen. This one article, my lord, my lord, it appears, or my lord, it appears to be a prosecution case, because one article stolen by one person, it does not generally happen. It is generally stolen in a group, and they say one, this churi from you, this one ring from you, and this way they continue to all the 412 charges.
What is the wrong in that?
Wrong in the sense, my lord, when an offense is committed in a bus, no
Not of
accused
the
will,
same date.
yes, my lord, when no accused,
All
same
the-
date. I'm grateful.
Page 22 series.
Yes, my lord, same date. Although, my lord, no conviction, but point is that, my lord, if a person goes and starts snatching, he will not snatch single and he will not leave by snatching first one. What they do, subject to lordship's kind sanction, when they start snatching, they will start from 1 to 34. All of them, and somebody else will be collecting. One will snatch, another will again go and snatch, that will not happen. So this way they tried to, but no such evidence was there perhaps.
Yes.
And the, my lord, charge sheet is in very old and torn copy. Charge sheet, I got a, my lord, note. Charge sheet sections are there. Kindly give me a moment, my lord. My lord, charge sheet number was charge sheet of 2003, 3rd September 2003. Sections were 396.
Which is in which page?
My lord, that is in the lower court records, nowhere in the paper. My lord, only thing is that along with
Chart sheet page?
my lord, in the lower court records.
Yes, what is
my lord, it is not paginated, my lord. It is not
What?
paginated. Written there, I found that. My lord, 25-27 Arms Act was there. What I beg to point out, my lord, I am just repeating. This 25-27 Arms Act was a vital thing. Unless the arms sanction was taken and the weapon of offense is sought to be proved, my lord, the defense gets the advantage, because there are judgments. If weapon is
We
used,
have argued that. We have
yes, my
taken
lord,
note
if
of
weapon is used and the ballistics reports are not matching, or some left thumb impression is not taken from that weapon, then presumption of innocence will come to the defense. It will not help them. And my lord, they failed to prove that angle of 396, because 396, together with that, your lordships will kindly keep in mind, 5 to 6 accused persons were never arrested. So it was never clear who at all fired. And one peculiar thing I found, my lord, in the evidence of, in the judgment, one SI stated that while arresting Chimu, he was shot at. my lord, that is in judgment, just a superlative affects. I'm not saying anything. Only say that Sanjoy Goldar and Chimu, both of them were arrested at the same go, and Chimu was fired at and he fell down on the ground. So I don't know, my lord, just to say this much, not more than that, that whether Chimu was at all involved or he was just brought to this field. Because, my lord, that comes in the evidence. Prosecution cannot deny. In the judgment, your lordship will find in the judgment that PW I am saying, SI's name, he said that I am an SI of DG. I had fired at him and he fell down.
Yes,
Yes, my lord, that is in.
yes, that is there.
Yes, my lord, I'm great. Then, my lord, another thing your lordships will find in the examination of Chimu, my lord, paper book page 633. 633. One question was there. Part 3, my lord, I think. Paper book part 3. Page, volume 3, page 633. Question number 496.
Volume 3.
Volume 3, my lord.
Page 633.
633, my lord. There it was stated in the 376 only to point out,
Question?
my lord, 496. One Babu Bala, your lordships will find he committed 376. Regarding that statement of confession which was retracted, from there it stated Babu Bala was laughing. He also committed. This Babu Bala I found, my lord, was never added.
Charge them which 25
Babuwala charge was framed.
Your lordships can see regarding Babu Bala, I did not
You did not?
find any admittal matter. Then 25-27 charge was framed. Charge 25 pages.
Can you give us that page?
The page number is different. That is the
Page
Yes, and you give both the numbers, we will get it.
39,
39.
35.
Past paper book.
First charge has not been
আমার পেপার বুক এটা নেই।
Pardon?
First charge.
That is not.
My lord, in my paper book, my lord, it's not.
Show it to him. Show it to him. Then 25-27 was at.
One is there against Babu.
This charge is complete.
This is what is the previous page whose name is there? Previous page and the lettered page tell us.
previous space also Babubala, 396, 376, 2G, 354. And later page, there is no charge.
Then answer
25 1. But this page is not in my paper. Not in their paper. No trial, I think. Trial page 25 1. But he also admits that no discussion.
then it must be there in the LCR.
Must be there.
You kindly check it up. এই LCR টা দাও না।
Trial has to be in subjectual or substantial. Trial or finding must be.
আচ্ছা, you proceed, all right. You were showing us page 633.
Yes, my lord. Only to point out that Babubala allegedly was involved in some G as per the retracted confession. That question. From there, I found this.
Listen, at the time of your argument, prior to that, you check it up. Now you can see. Yes. Yes, you proceed. You proceed. What is your next point?
পাঁচ ছজন ছিল, কয়েকজন বলছে 3-4 জন, কয়েকজন 4-5। সেগুলো ক্রসে যখন কেউ বলেছে 5-6 জন, এই পয়েন্টটা চ্যালেঞ্জ করে। বরং ক্রসেও বলেছেন এগুলো ইয়ে করে পেছনে করে গেছে। এখানটায় কিন্তু চ্যালেঞ্জ যদি 5 জন চ্যালেঞ্জ না হয়, অবজারভেশন দাবি করতে পারে টোটাল দুটো বাস মিলিয়ে কজন ছিল। 5 জনের জায়গাটা যদি চ্যালেঞ্জ না হয়ে থাকে, এটা এখানে ডিসকাস করেনি জাজমেন্টটা। এইটা একটু রাখা দরকার ছিল। যদি একটু 5 জন ছিল, কাজটা হয়েছে, তখন সেইটা আইডেন্টিফাই পার্সন আইডেন্টিফাই
8 October 2012.
8 October 2012.
And one of the
পাঁচজন ছিল না এটা একদিন আইডেন্টিফাইড হলো না সেটা অফেন্স যেটা হচ্ছে অফেন্সে পাঁচজন যদি প্রমাণিত হয়েছিল তাহলে অফেন্সটা প্রমাণিত আইডেন্টিফাইড না because court take cognizance of the offense.
And one
Judgment was of 2009.
Day of October 2012.
Judgment
No, charge framing is Babu Bala.
after delivery of judgment.
Separate trial has been
Oh, separate trial.
must be
Absconding ছিল ফাইল ফর দি প্রেজেন্ট হয়েছিল it was filed for the present possibly after arrest a new trial began.
But why that is not there in our paper book?
That is not decided possibly.
that we do not know. One more thing, my lord, in the lower court records from the FIR that order sheets, those are missing. I did not find. My lord, perhaps it is not complete.
Tell us one thing, number of witnesses stated there were 5 to 6 persons. Number of witnesses stated. Some stated 3 or 4 persons, but other number of witnesses stated there were 5 to 6 persons. You did not ask any question or challenging this in cross-examination.
Well, if your lordship is kind enough to give one more thing.
How long will you take? How much time will you take? You have almost finished.
Almost finished.
So how much time will you take till?
From 2 PM it will serve my purpose.
Entire day we cannot give you. They have to. This is a different bench. We are finding it problem to keep it.
My lord, what has today fallen from my learned friend regarding subject to lordship's kind sanction, that what happened to the 25
25.
relevant for this trial? This appeal. That
How
means
it will be relevant?
if anything is, my lord, occurring, this link, because we shall try to take advantage. I am just pointing out.
396 মানে একটা মার্ডার ছিল, স্যাংশনটা নেই, আর্মস একটা কগনিজেন্স নেওয়া হয়নি। ডাউটফুল কেস বলছে যে 302টা ডাউটফুল, মানে মার্ডারটা ডাউটফুল, কেন চার্জ করবে? বাট আদার এভিডেন্সেস আর দেয়ার, টেকনিক্যালি কি সেটা পয়েন্টটা দেখতে হবে।
Suppose যখন শুরু হলো, এবার স্যাংশনটা নিয়ে ওটাই পরবর্তীকালে হ্যাঁ হলো কি না
স্যাংশন হলে আর্মস অ্যাক্টের কেসটা হবে না, আর্মস অ্যাক্টের স্যাংশন হয় না। 302 হচ্ছে যদি প্রমাণিত হয় কি আছে, 396 প্রমাণিত হচ্ছে তার তো স্যাংশন হবে না, আর্মস অ্যাক্টে স্যাংশন হবে। দ্যাট শুড নট স্ট্যান্ড ইন দি এরকম একটা গ্রুসাম মার্ডার যদি হয়ে থাকে, আর্মস অ্যাক্টে স্যাংশন 396 এর জন্য স্যাংশন আর্মস অ্যাক্ট কেন দিবে? স্যাংশন নেই, আর্মস অ্যাক্ট
All right, you leave that point. What is your next point you are arguing?
One more day can I get my
We will give you. We are still having time.
another point was that, my lord.
And not at the cost of repetition. If you can finish it, you say.
My lord, in the charge sheet I have told you, lordships, 25-27, there was one supplementary charge. Charge sheet of 2003 September, supplementary charge sheet of 1st June 2004. 1st June 2004 against Kurban Ali Mandu, Yashin Vishwas, Ikka Khan, Babuwala, Dilip Joy Savara. My lord, 5. In all 5. Supplementary charge sheet is 5. That is also in the lower proceedings.
Yes, that is in the judgment also.
Yes, but here I found from the order sheets against 2, Dilip Joy Savara and Ikka Khan, they were never arrested and their case was filed for the prison. So these 2 never faced the trial. 2.
What are the names you said?
Dilip Joy Savara. Dilip Joy, J-O-Y Joy, in Savara, S-O-W-A-R-A. And Ikka Khan.
So how many persons? Dilip Joy Savara is one person.
One. Another is Ikka Khan. Against 2 case filed for the present. And the supplementary charge sheet against 3 more persons. One of them is Babuwala. Another is Yashin Vishwas.
And Kurban.
And Kurban faced. So my lord, my humble attempt is, if Babuwala against him 25-1A, my lord, it is relevant as per Evidence Act. If 25-1A, if my lord, from him it is recovered, and if in that, if he has faced a trial, and there one ballistic report, if at all, matches with the my lord, bullet fired, my lord, that will be helping us, because then, subject to your lordship's sanction, why shall we be, my lord, because we are in 2003, this is, my lord, from the date of arrest almost.
But we shall consider that.
All of us. Now, my lord, if the main fire is not by us at our instance, my lord, that trial has some bearing, because if you do not know what has happened to that Babuwala. My lord, I think subject to lordship's sanction, you kindly consider whether a report regarding that trial, that charge, whether that would be needed or not.
All right, you prepare whatever you have argued, you put it down in a short note, along with the other 2 points which you will argue. So you give us that, and then you give an advance copy to them. Then they will come ready.
Today I could not, my lord, kindly excuse.
Can you do this? If we fix another date, we will be fixing.
Absolutely.
What we are proposing, suppose we have 1 or 2 points here to submit. Those points you put in your written notes of argument along with today's argument, and file the written notes of argument so that next day we can hear the prosecution.
And another humble prayer, only one thing, and you not take me as my lord, they did not surrender, subject to your in time. Now,
All right, you put all these things in your notes of argument.
because for that it is a serious offense, because these persons are already, much of their life is spent.
All right, you put all your questions and they must file it on the next date.
Well, can I put some judgments also?
Absolutely.
Yes.
You can annex those judgment, or if you do not have, the judgments are not available.
So we'll be giving it, no?
My lord, by the next date, we will also prepare the written notes of arguments. We will serve.
In
my lord-
advance.
Yeah, we will serve the state the advance copies of the notes of argument, and my lord, we will file the
But
written.
we have already prepared the written notes of arguments, Lord, for this case.
Then very good. They will give you advance copies. You
Can-
have prepared. Give it-
Can I file this today, Lord, with a copy to?
Let them file so that you
Let
can
them
answer
file
that.
So that you can answer. If
No,
you
Lord,
want
not
to
answer.
add that,
Oh, yes, yes.
after seeing
answer
that, if
to
you want to add anything to that, you add it.
My lord.
Today he has argued as regards the 25 Arms Act issue, which we told him. You also considered that fact also.
We have one query. Number of witnesses, they stated number of persons were 5 to 6. That is more than 5. No cross-examination, no question, no challenge was made in cross-examination regarding that number.
Number, Lord, we have the arguments over this because, my lord, the others, Lord, 4 or 5 persons still are absconding.
There is no reflection on this point in the judgment itself. Judgment should not say something.
Absconding কথাটা বলা আছে তো? Yes, yes, it was reflected that the others 4 or 5 persons are absconding. In that event, we
It is
Lord,
not
it could have, Lord, because 4 persons and 4 are absconding. So, Lord, they are, Lord, and it has been reflected in the judgment itself. And question of numbers, Lord, your lordship can satisfy over this, subject to correction.
এই জয়ন্ত বলো সাহেব। কবে বলে রাখলাম।
বাবু বলার অ্যাপিল নাম্বারটা আছে বলে দিতে হবে তো দয়া করতে হবে।
হ্যাঁ বাবু বলা বাবু বলে কি হচ্ছে তাই কি জানি।
হ্যাঁ?
Giving.
আরে বাবু বলে নাম্বার দিতে হবে তো ইয়ে হচ্ছে
আপনি একটু ওকে তৈরি
না অ্যাপিল ফাইল হয়েছে বাবু বলার অ্যাপিল তো হয়নি।
কনভিকশন হয়েছে তাই তো জানি।
জাজটা মরে গেছে বোধহয় যে জাজমেন্ট দিয়েছে মারা গেছে
তাহলে আমরা
যে জাজমেন্ট দিয়েছে যা মারা গেছে। আরে ভাই শোনো
কিছুদের মতো কিছু না করে
বুঝলি কোনো পালাই না মামলা শেষ হবে।
Can you come back on 5th July?
Not only blood, super is blood, another name blood is appearing Babu Bala. Blood, we can not find out from them the land code below.
Yes, you did.
Because that judgment, blood, if judgment comes, but your lordship cannot decide this whether Babu Bala has been acquitted, was acquitted, or was convicted. We do not know. But your lordship kindly blood pass an order to that effect so that we can blood come with the report from the court below.
We have to consider on the basis of the, because they were absconding.
Absconding subsequently was arrested 2012.
So maybe you have to argue that that nexus will not spoil the case which is here.
My lord, my lord. No, my lord.
Because one of his argument is that will spoil the case. So you certainly cannot say that give me more time so that I can.
No, not more time. By this time, my lord, we can.
Suppose that trial is not over yet. Then what will we keep the matter pending?
No. I'm not asking that. Your lordship can know what is actually the effect of the Babu Bala.
You take
what
that
has happened.
instruction and tell us.
Yes. But
Mr.
your lordship
Manager,
kindly pass an order to that effect one line.
that is beyond the scope of this appeal because we don't know because when he was arguing also we were not finding about that charges as respect of Babu Bala in the paper.
My lord.
Then it was
My lord,
pointed
my
out
lord.
by him.
এটা জেনে নেবে খবরটা।
Please take that instruction and they can suddenly come with all the whatever records pertaining to that you give it to us. Let us see. That is your argument. We shall also check. You know.
But I have already told Millard for taking these steps to them.
ওই অর্ডার
Mr. Moitro, the learned counsel appearing for কি হবে ওটা?
নাম দিয়েছো?
For the appellants
না, এই একটা
and
কাগজ
Mr.
দেবে?
Chakraborty appearing for, you are for Kurban Ali, Chimu Sardar,
হুম?
submitted their respective arguments. Both the counsels crave leave to file written notes of argument
আমরা জীবনের শেষ মানে নাম লিখে লিখে
on the
যাবো।
next date. Same is allowed.
ওদের প্যানেল থেকে বেরিয়ে গেছে।
Fix.
হলো না।
Call it, no?
5
5th July. 5th July for hearing further argument.
এই যে
as
এই
fixed at
To be fixed at 2 p.m.
আমার মনে হয় ওয়ান ছিল।
in particularly of prosecution.
তাহলে আসবো বলে বলে গিয়ে
in particularly a prosecution.
কোথায় গেল?
দেখে তো,
দাদা
ওটা আজকে তো তুমি সকালে ছিলে না, ওটাকে কিন্তু ওটা কিন্তু কোনটা ওটা বলছে যে রেকর্ডিং অফিসারের কাছে ওই আপলোড সাকসেসফুল হয়েছে কিনা সেটা তোমরা দেখতে পারো। বলছে ওটা যদি আনসার